Number 3, Lordship, just for the day.
1 second. Let me just quickly settle down.
Yes.
Item number
3.
3. What do you want?
Dear Lordship,
Yeah, for the petitioner.
petition.
As prayed for by MSS Praveen, learned counsel appearing for the Parveen, learned counsel appearing for the petitioner, relist on any date next week. to be fixed
Lordship,
by the registry.
Tuesday, Lordship.
Welcome. Yes, next.
Oblige, Lordship.
May it please your Lordship. I take to mention item number 4 and 5 on behalf of the respondents higher education department.
You're there.
For the petition.
As prayed for by Mr.
A.R. Tohvildar.
A.R.
Tohvildar.
Tohvildar, learned standing counsel.
Lordship.
Higher
Higher education.
Higher education, which is objected by Mr. K. Mohammed, learned counsel appearing for the petitioner, relist after 2 weeks.
2 weeks. My lord, can I pray for a week, my lord?
After a week on a date to be fixed by the registry.
My lord. I'm deeply. All right.
Lordship, with the consent of the other side, I beg to mention the item number 15, Lordship. It may be listed after 1 week, Lordship.
15.
Yes, Lordship.
You are for?
I am from appearing for D. Mondal, Your Honor. He is absent, Your Honor.
If he is for whom? For respondent.
Okay, respondent number 1 to 8, Lordship.
Have you informed the other side?
Yes,
You have.
Lordship.
As prayed for by Mr.
R.D. Bhuyan.
R.D. Bhuya, on the ground that Mr. D. Mondal, learned counsel appearing for the respondent number 1
to
is?
8.
1 to 8 is
Uh,
out of station. What did you say?
Some personal problem.
Is having personal difficulty today,
Lordship.
which is not objected by the learned counsels appearing for the appellant, relist after
1 week, Lordship.
after a week on a date to be fixed by the
Yes,
registry.
Your Honor.
And a date did you get to Rona matter?
Highly obliged, Lordship.
Please call the list.
Admission item number 1.
Pay parity.
Yes, madam. Here, my lord, petitioners, teachers of
Yes, who's appearing for Director Ayush?
Mr. D.P. Bora was appearing.
Mr. Bora,
Yes, ma'am.
you are there?
Yes,
I think you are supposed to apprise as regards the status and ongoing development measures.
my lord.
Last occasion, he has submitted one instruction, my lord.
We submitted one the instruction, my lord, and thereafter, my lord, now the position is that, my lord, the process for appointment of the principal of the college is going on, my lord. Actually, during the last advertisement process, there was no suitable and eligible candidate for the post of principal. Subsequently, an advertisement has been issued in the national level. Now, my lord, just now I have obtained the instruction that last date of submission of the application was 31st, my lord, and some applications are there, my lord. So the process for the appointment of the principal is going on. Actually, my lord,
But how much time will all this take? Because it is affecting public at large,
yes,
the delay.
no, my lord, otherwise the functioning of the college has been improved, substantially improved, my lord. On last occasion also, I have submitted one
Communication, 14/10/25.
Yes, my lord, containing a report, my lord.
What do you want today?
My lord, some time may be granted because now the instruction is that once the principal is appointed, because in the last round of advertisement, there was no suitable candidate in the state level for the post.
Now that process is on.
If the advertisement had been issued in the national level, so now some applications are there.
How much time?
Another 4 weeks, my lord.
My lord, what I would like to submit, this subject matter does not have any bearing with the appointment of principal. We are claiming pay parity. The teachers, out of 13 petitioners, 10 have already retired during pendency of this, my lord. 1 died in harness, 2 are serving. Lord, they are claiming pay parity with their counterpart of allopathy and Ayurvedic. And it was the stand of health.
There is the impediment of going ahead with the hearing. The pleadings are complete.
Pleadings are complete,
We
my
have
lord.
filed affidavit,
Then
but Regarding
Feelings are
the pay parity, my lord, the Supreme Court has clearly held that, my lord, the Ayurvedic doctors, my
That
lord,
is on merit.
Yes.
yeah, on merit.
That is
my
on
lord.
merit.
But my lord, subsequently there was a decision, my lord. There was a decision by the cabinet, my lord, that my lord, the functioning of the homeopathic college may be improved, my lord. And after the improvement of the functioning, my lord, that may be considered, my lord.
Where, which is this order?
There is a communication, my lord. Because there in the record, but your lordship may peruse it.
Yes.
Yes, sir. Edinburgh, my lord. Now, my lord, it has been.
One
substanti-
second.
Yes, my lord.
No, but you see, this says that the proposal has been placed. This is they have sent a proposal. Director, the medical education and research department was directed to prepare a proposal for the extension of the AICTE pay scale benefits. I think that is
Yes,
your
that is
prayer.
my case.
The proposal was placed before the Honorable Chief Minister, who opined that by processing the instant proposal for consideration before the cabinet, substantial compliance with so and so has been achieved. So what is the status of that proposal? This court is concerned with that. The subsequent part of the communication is not having a much bearing on the relief that the petitioner is seeking in this petition, because it says to further justify the proposal. That is a consequent action. It was suggested that Ayush first take steps to improve the functioning of the newly amalgamated homeopathic college, specifically in terms of so and so. Only after these improvements are made should the enhancement of pay scales be considered at a later stage. But this is a communication dated September 24. Now, what has happened to this proposal? Is it kept on hold? Because you see, the first part of the order says processing the instant proposal. Because the order of the court is to prepare the proposal. Now it appears that the proposal has been placed before the cabinet. That is one thing. Simultaneously, you can go on improving the whatever services you want to do. That is subsequently different.
Yes,
It has no bearing with the pay that they will get.
no.
So, Mr. Bora, I am not saying anything today. You please look into it.
Yes.
Come up with an appropriate instruction, because this instruction is, I understand, but then you see, it has no correlation with the relief that has been sought. And this communication also shows that it has been processing. But processing doesn't mean it will be kept on hold.
If it shows September 24.
But if you read
November
together, looks like perhaps it is kept on hold. Mr. Nayak, you are for the? So I think your role doesn't come immediately.
At this stage, no. This proposal was submitted before the finance.
Yes, you see, that is, I think I should ask, I think Mr. Bora, you place the exact status of the proposal. I think that would,
My
yes.
understanding of this letter is concerned, Lordship,
Yes.
Lordship comes to the last line of the first paragraph.
Yes,
Only after these improvements are. made.
correct. But then you see that in that situation, it is contrary to the order of this court. Because you see the first part, I am directed to inform you that prima facie it appears that the Honorable High Court directed the Medical Education and Research Department to prepare a proposal for the extension of the AICTE pay scale
Lordship,
benefits.
in fact.
Correct.
In terms of the report of the annually committee.
Whatever. Now,
So
it
was
then
not specifically
then you say, it says the proposal was placed before the so and so, who opined that by processing the instant proposal for consideration before the cabinet, substantial compliance with the Guwahati High Court's order has been achieved, and says to further justify the proposal. These are the steps required. You see, I understand your concern, but you have to also expedite.
Yeah, this
This-
later portion.
this has to be expedited, because otherwise it defeats the prayer made here. They are going to be kept hanging on the name of develop the services and all that changes to be brought. We don't know when those changes will be brought, isn't it? So I am not saying anything today, Mr. Nayak. I am not saying anything today in this order. I am only indicating the mind of this court so that you all have a discussion, take a conscious decision how to go ahead, because it is only a question of going ahead with the proposal. It looks like in principle, no one has a serious objection for not approving the proposal. If that be so, you take a conscious decision. Otherwise, this petition will be kept on hanging.
Then that concern is also open for the authority lordship in terms of the NMLA committee.
So do whatever is to be done. You
Health department India affidavit
So
has
you
stated
do
they are
whatever is to be
Allow-
done. I'm only indicating that something is to be done. Otherwise, we don't know how much more time these services will come into effect. Until those services don't come, the proposal may be kept hanging. If it is already placed before the cabinet should take a call. Isn't it? Heard Mr. Your name KM Haloi. KM Haloi, Learned Counsel for the petitioner. Also heard Mr. BP Bora, Learned BP Bora or D? DP. DP Bora, Learned Standing Counsel, Health and Family Welfare Department, and Mr. P. Nayak, Learned Standing Counsel, Finance Department, stroke Additional Advocate General for the state of Assam. It appears that though a proposal was placed before the cabinet for processing, however, the communication dated 21/9/2024 placed earlier before this court by Mr. D.P. Bora, Learned Standing Counsel, indicates that the director of Ayush has been requested to submit a recent report on the policies adopted for improving the functioning of SJNHMCH, particularly in the areas of academics and patient care services, and a proper review of this report is necessary before the pay scale enhancement for the facilities of SJNHMCH can be processed further. Stop. Considering that the issue involved in the present list is the enhancement of the pay scale of the petitioners, stroke faculty members of SJNHMCH, এটা full form টা আগত দি পেলাই here after কৰি দিবা, comma, let an up-to-date status as regards the time frame within which the policy can be, within which a decision as regards the policy which is pending before the cabinet can be taken. I think that is good.
Yeah, fine.
You indicate what's and in the event there I think that should be good right now. You find out, because we need some concrete information, otherwise it will go on. Relist after
4 weeks. my lord.
maybe on a date fixed.
at a date
15
given on such and such date. Yes, next.
Obliged, my lord.
Item number 2.
May I please, your lordship?
Yes.
My lord, here matter pertains to my lord, provincialization of services, my lord. My lord, herein that SSA has been my lord, newly implemented as a respondent number 10, my lord. After my
Who has
lord,
been implemented?
my lord, SSA, my lord, direct mission.
So
direct-
anyone appearing?
my lord,
SSA, I don't know, my lord. Oh, I am appearing for response
Mr.
number
P.
eight.
No, but the
Mr.
duly implemented respondent, anybody anybody,
my lord, Mr. P. Nayak's name is appearing.
huh? P. Nayak.
No.
Mr. Nayak, has he left? I don't think he's gone far. Send one of your junior.
My lord, I have approached to some of the councils, my lord. They had but to serve the copy. They said, my lord, the case has not been distributed.
my lord, I will serve him the copy today itself.
Oh, you have not yet served him a
Not yet,
copy.
sir. During the course of the day, my lord. I will-
All right,
There's an interim order, my lord,
operating against you.
against me, and it is on the wrong premise, man. That is the.
Anyway, there's no IA otherwise, no? File for
No,
vacating.
I was disposed of, he included the, oh, no, I for vacating, no. We have filed affidavit.
All right, all right. You serve a copy
My
today
lord,
itself
my lord,
then.
today
So there
itself,
is a
sir.
standing counsel.
My lord,
What is the name of this newly imputed respondent?
I'm a mission director, SSA, my lord.
Is Mr. Nayak representing the mission director? He does.
Yes.
No, if you can have him here, then I will record it and I'll expedite the hearing. Otherwise, since there is an interim pending, Mr. Goswami, why don't you ask one of your junior to get hold of Mr. P. Nayak?
Earlier order, lordship.
For this very newly imputed respondent. No, on the last occasion, it says petitioner is permitted to serve notice to the respondent number 10 through P. Nayak. So that you have not yet done.
Not done, my lord.
Then do it. Why are you not doing it? This was
But
given
I
in
have-
June and there is an interim against you. If you don't do it, I will vacate the
No, my
interim
lord,
then.
my lord, today itself, I will serve, my lord. I have.
You do
I
it today, I'm posting it
Yes,
next week.
lord.
Otherwise, the interim will get vacated.
My lord, today itself, my lord, just now.
You are Mr. BK Das.
My lord,
Heard Mr. BK Das, learned counsel for the petitioner. Stop. Also heard Mr. B.D. Goswami, learned counsel appearing for
8 and 9.
respondent number 8 and 9. Who else are there?
1, 2, 4 and 5.
Mr.
P and sir.
P. N. Sharma for
1, 2, 4 and 5.
1, 2, 4 and 5.
4 and 5.
And
47.
for respondent number
7.
7. Fukan, respondent number 3. You're also there. Then appears for respondent number 10 on call. It appears that though by order dated 19/6/2025, the learned counsel for the petitioner was permitted to serve notice to the respondent number 10 through Mr. P. Nayak, learned standing counsel SSA within a week. However, despite of the aforesaid judicial direction, the learned counsel has not served the same upon the learned standing counsel. Stop. Mr. So-and-so assures that a copy, that the notice shall be that steps shall be taken during the course of the day by serving a copy of the petition to the standing counsel SSA. Stop. In view of the aforesaid assurance, relist next week on any date to be fixed by the registry. It is needless to be clarified since an interim stay is operating in favor of the petitioner if the service as directed earlier by this court as well as reflected in today's order is not taken, necessary orders for vacating the interim order shall be proceeded.
Number 6.
Yes, Mr. Kaushik.
Leadings are otherwise completed.
Lordship, may I, Lordship?
Yes,
I'm
please.
appearing in person.
Yes.
On 14th of October, I was directed and allowed to file an additional affidavit. Some more development has happened, Lordship. I have filed yesterday.
Your name is Anubrata Datta?
No, Anita Datta. I'm appearing in person, Lordship.
Anita Datta.
Yes, Lordship.
Yes. Ms. Datta, you have you want to file something more?
Yesterday only I have filed it.
You have
Lordship.
filed the additional affidavit.
Yes, Lordship.
I don't think it has come on record. The additional affidavit that you filed yesterday
Yes,
has not come on record.
I have the receipt, Lordship.
No, that's all right. So I will ask the registry to place it with the record.
Yes,
And in the meantime, you want to file something more.
No, nothing has happened. It is not on my side, Lordship. Actually, I received one letter from the respondent number 6 and who is the director of pension. This letter is not referred to me, but only it has been forwarded. The letter has the letter is here, Lordship. If Lordship wants to have a look only,
Where?
here it is, Lordship.
What is the issue
The issue is lordship, delay in disbursement of pension,
Pen-
lordship. Yes, lordship.
This is the affidavit which you filed yesterday.
Yes, which I'm not so much of concern about this, but only I have received. So,
So which letter? This 18-1?
yes, lordship, 1810.
18?
22nd 9, 2025. I received.
Page.
No, this is a new letter, lordship.
Where is that letter?
The letter is there on the annexure 1, lordship. And I have served the respective respondents, lordship. It is in page 204, lordship.
204.
Yes, lordship.
Yes, I've got it. So voluntary retirement is not admissible according to them.
It is already admitted, lordship, because I have just annexed here also, which has been approved, sanctioned, everything has happened. On the basis of this, I'm receiving provisional pension since last almost 20 years. On the basis of the rule of this Assam Service Pension and Manual, which has been clearly written, and in the Assam Service
All right,
Pension.
Ms. Datta,
1969.
since this formally the affidavit is not on record, I'm posting it next week. Because it has to come or any other date that is convenient to you, because this has to come on record.
Yes,
You could have called it in the morning. That was a different situation, but right now it's not on record. Yes, Mr. Kaushik, you want to say something?
No, my lord. Otherwise, pleadings are complete. We have filed our
So
affidavit.
it can be posted for hearing.
Yes.
my only submission is lordship. If lordship comes to the letter, it is.
Ms.
in-
Datta, you
Yes,
see
Lordship.
this additional affidavit that you
Yes,
have
sir.
filed yesterday
Yes,
is
sir.
not placed
Okay,
formally
sir.
on record.
from lordship.
So I'm only posting it next week. Please make all your submissions when the additional affidavit is on record. It has to come on the record.
Yes, Lord.
So handing over a copy from that side will not do, Ms. Datta.
Oblige lordship.
So,
In this case, lordship.
Any date you
Yes,
want,
yes, lordship.
I will accommodate you, Ms. Datta.
Highly
uh,
obliged, lordship.
Heard MS A. Datta, the petitioner in person. Also heard Mr. B. Kaushik, learned standing counsel, Secondary
Secondary
Education Department, representing the respondents concerned. And yes, B. Sharma,
For 7 and 8.
respondent 7-8,
Yes.
the Deka, Barpujari,
Ten.
for 10, Fukan for 6. MS Datta, learned petition, don't say learned, the petitioner in person submits that an additional affidavit has been filed yesterday, i.e. so and so. However, the same is not on record. Let registry verify and place the same on record. Relist on, yes, Ms. Datta, when?
18th of December, because I have
All right.
from the other state, lordship.
No worry,
Yes, sir.
18/12/2020. And if you wish, you can also participate through video conferencing, whatever mode is convenient to you.
Because I am practicing here, there, lordship, in Calcutta High Court.
All right.
Sometimes it's very difficult in the virtual appearance.
Okay, no, I'm just indicating.
Yes,
All right.
yes, lordship.
Yes,
Pardon you.
next.
Oblige.
7 and 8.
Your Lordship, the Department of Higher Education's, the Secretary is required to file an affidavit, Your Lordship. That was
Who has to file, Mr. Sinha?
the government in the Department of Higher Education.
Who is appearing for that government?
I am appearing.
Yes, what about your affidavit?
Lordship, we have communicated with.
You were granted 1 week time on 17th, but that was only 17/10.
Otherwise, Lordship, we have communicated, but we have not received the instruction.
All right, we'll give you a further time. Mr. Chalia, you're also here? All right, let the higher education, na? Let them complete their return. Heard Mr. R. Sinha, learned counsel appearing for the petitioner. Also heard Mr. A. Chalia, learned senior counsel, assisted by
M. Roy.
Lordship, I'm appearing for UGC.
M. Roy for UGC.
No, Lordship, I'm Dr. P. Agarwal. I'm appearing for UGC.
No, but I said no, sorry, not H. Chalia. BP Chalia, you are appearing for whom?
First, the petition is for respondent.
All right, please give your appearances. Mr. Gogoi, just facilitate giving all the names. As prayed for by Mr. So and so, Learned Council appearing for the higher education, relist after how much?
2 weeks.
2 weeks on a date to be fixed by the registry to enable the department file affidavit in opposition in the matter.
Lordship, 3 weeks maybe, but
No, 2 weeks. You've already taken 1 week.
No, they have been taking time since
Yes,
long.
Mr. Sinha.
That's deeply obliged, Your Lordship.
item number 9.
This petitioner also, he has retired from service on 39/2023. I am yet to get my pension, Lordship. Although,
Yes,
Lordship,
why pension not given and no affidavits, nothing filed?
Lordship, the AG has raised an objection that when I was got under the regular establishment in the year 2011, there was no approval from the government. In fact, Lordship, the PW is just transferred subject as per amendment to the 6th schedule of the Constitution, and there is already an approval by the government at Annexure 2.
No, but you have to,
Yes.
you haven't filed your affidavit.
No, Lordship, we have sought for our updated instructions, Lordship, and the same is awaited, Lordship. Your Lordship,
So
I
you
kindly want-
completed, it's a matter of pension. Now, if there is any objection, there is any hurdle, you put it by way of your response. Let
Yes,
us see
sir.
what is the hurdle, because you can't sit over the pension, na?
Lordship,
Pension
Lordship,
keepers.
page 18, Lordship, approval is already given by the Lordship.
So
government.
after approval, why it's not released?
Lordship, may kindly grant us.
I shall grant you the time, but please expedite the
Even Lordship, the gratuity amount has also.
in fact, on the last occasion, because there was no one on KAC, you are for KAC. Because of your absence, the matter could not be progressed.
Yes, Lordship.
Because Mr. Talukdar, I think he has already given his instructions. It appears that as regards the objection raised by the Accountant General, the Executive Engineer PWD RNB Mechanical Division DFU KAC has not resubmitted the pension papers of the petitioner, for which the matter is not being able to progress at the end of the office of the Accountant General. So why are you delaying the progress, and here you are taking time for filing return? Why they are only asking you to resubmit the pension papers. You resubmit.
But instructions are still awaited, Lordship.
Instructions. You see your name?
V. Shohei, Lordship.
B.
V. Shohei, Lordship.
B. Sohor.
Shohei, Lordship.
Shohei. Miss Shohei, I understand that your senior must have instructed you to seek time. But that doesn't mean repeatedly you will be submitting only that before this
Yes,
court. Try and follow the queries that the court is posing to you.
Lordship.
You are appearing before this court
Yes, sir.
as an officer of the court.
Mm.
So right now, you must be responsible to address the court. Correct? I understood that you are waiting for instruction, but please understand what is happening also.
Okay.
Have you seen the last order of the court?
Yes, Lordship.
What does the order say?
That we have to resubmit the.
Correct. So only thing this court is now asking you is that how much time? So that instruction can be obtained over the phone also.
Not-
You don't need a long time to file return for that. Because this matter involves pension benefits, right? One cannot be sitting over it also. The Accountant General have raised some objection. They want you to resubmit, give those clarification, do it. Isn't it? Mr. Talukdar, that is all that is required.
Lordship, may I point out one thing? Already, Lordship, they have raised an objection, and resubmission was done on 19/10/2024, Annexure 7, page 20. 19/10/2024. Page
Ni-
26 of my. Lordship,
1910
2024.
20?
4.
No, but this
But again, they have raised an objection.
correct. So now see, if they have raised an objection, let them resubmit so
No.
that then we
Yes.
can proceed.
Yes.
Because they are neither they are resubmitting nor appearing before this court. Now after appearing also, they are saying awaiting instruction now. That becomes difficult for the court to progress. So how much time do you need
Lordship, a week's time.
for placing this instruction?
Or Lordship, your Lordship may fix it for two, Lordship, and might
At
change for
two?
the price to court, yes.
Very well. At 2. Let her senior be here. At 2. But you coordinate with your senior what had happened in the court. So he can give a call to the officer concerned and see why the resubmission is taking time. All right? At 2.
Supplementary again. The number 26 and 27.
Yes.
Last occasion, 7/9, the APDC was supposed to file an affidavit to bring on record the expert committee's decision. What has happened here, my lord, is that similarly situated people, when we were appointed and were given sanction post, those who were given the boiler junior assistant, they got a higher pay grade and pay band, whether the similarly situated people were not given the same pay grade. Now, my lord, on this situation, they say that they are working in a hazardous conditions. Now, this expert committee was trying to find the anomaly in that ROP 17 with the revised pay. If that affidavit be filed, it would be easier to adjudicate the matter on that.
That has not come.
That has not come in.
I agree for the APGCL lordship.
Who has to file that?
My lord, they only has to file the
APGCL.
last date, you only undertook to file it.
No. I agree for APGCL.
Oh, GCL. TCL has to file, not GCL he appears.
Who is appearing for GCL? AEGCL.
APDCL, my lord. He is appearing for APGCL.
Lordship, he is appearing for.
My lord, I'm appearing for APDCL. Lordship.
APDCL.
Yes, sir.
Yes.
Lordship, we are going to file the additional affidavit during the course of the day.
Okay.
All right.
I want to file it. Heard Mr.
J Singh.
J. Singh, na?
Yes, ma'am.
Learned Counsel appearing for the petitioner. Also heard Mr.
And sir,
N. Sharma, Learned Standing Counsel.
Lordship, I appear on behalf of.
Learned Counsel appearing on behalf of the Standing Council APDCL. And Mr. H. Das.
HR.
HR Das, Learned Standing Council AEGCL.
Lordship, APGCL.
APGCL. So,
Lordship, may record Mr. Dina, please. Standing on.
so and so on behalf of the NAT Standing Council APGCL. Stop. And Ms. K. Fukan for
APDCL.
APDCL. Just everything is going to go up. Confusion will be there in the order. Please, Ms. Fukan, just give the appearance leave of all the names. As prayed for by Ikhetor Nam to Divo, Potham, so and so to the effect that as prayed now, so and so submits that the additional affidavit or affidavit in opposition, additional affidavit shall be filed within the course of the day in view of the aforesaid relist when? Mr. Singh?
My lord, as per your convenience.
After a week?
After a week.
Relist after a week on a date to be fixed by the registry.
My lord, I appear only for item 26, not for 27.
Who is appearing in 27? 26 of Tikhetor Namdivo and 27 none appears for the petitioner. Ekelengi Didivo.
Obliged.
Item 28.
I can't do what I said. Yeah. Yes, Mr. Kalita.
Well, in this case, that sexual harassment matter, that matter relates to sexual harassment of women at workplace matter. That matter, I have received the report, matter. I have consulted with my client that she has told me that this written statement was called for, was sought from her, but she was never called, matter. And otherwise,
She will be called in due course. Because I think they have reconstituted. That was the subject matter, isn't it?
That was-
Non-reconstitution of the internal complaint. That
Yes.
has been done.
Yes.
And appears that she has also been called by the so constituted. Now, whatever it is
One
going to be
number
done, will go on done. Why should this petition be kept pending?
Yes, Malad, we have also, Helen, Lordship may kindly see the prayer number 3, Malad, that there is total violation because, Malad,
Violation of what?
violation of the provision, Malad, because, Malad,
For what?
there has to be an internal committee in the, Malad, organization, but earlier there was no internal committee. Only after lodging the
So
complaint,
which prayer?
prayer number 3, Malad.
Respondents were particularly to take necessary steps as per guidelines and norms. So that is for redressal. You see the prayers are.
Page 20.
I have page 20. Directing the respondent, more particularly respondent number 2, 3 to reconstitute the internal complaint committee. The respondents, more particularly the respondent number 2, 3, 4 to take necessary steps as per guidelines and norms for redressal of the grievances of the petitioner, imposing penalty upon the respondent for non-compliance, and setting aside the notice dated so and so, constituting the internal complaint committee. Now, all this has become infractious because they have already constituted a new. If you have any grievance, you will have to come by way of a fresh petition.
Yes, that is true. That is true, madam.
Mr. Kalita, please appreciate what has
Yes, yes,
happened.
I am appreciating, madam, but
Because
this-
in this, your
Otherwise-
main thing is the reconstitution as per the provisions and consequent actions for not doing it,
Yes.
the penalty
Otherwise,
and
madam,
guidelines.
report is appealable, madam.
So do
So,
whatever
madam,
you want to
They
do.
ought to have complete the, my lord, proceeding with the
But
line.
now, see, they have done it, so I don't think there is any reason for keeping this matter open. You have any grievance, that liberty will be given to you. They've already constituted it. Where is that?
I am concerned only about, my lord, section 26, my lord. Section 26.
What is
provides-
section 26?
Section 26 of the Act, my lord, provides the
Give me the
penalty for
act.
non-compliance of the provision.
Now they have already complied. Now some penalty provision. And that is going to be awarded by whom? Huh?
Judicial medicine.
So you take, if you want, you can approach. You can approach, do whatever you want to do now that they have done it, and if there is a delay, and if there is a violation of the statutory provision and that against that a penal provision is there, you take appropriate course. Because your prayer here, the main prayer was for that they have done. Which is the provision, Kalita?
Section 26, my lord.
Section 26. Let's see this. Where the employer fails to constitute an internal committee under subsection 1 of section so and so, take action under section so and so and contravene so and so, he shall be punishable. Yes. So, but this is to be cognizance. Who will take cognizance? No court shall take cognizance of an offense punishable under this act or any rules made thereunder, save on a complaint made by the aggrieved women or any person authorized by the internal committee or local committee in this behalf. So this has to be done. You take appropriate whatever is under the law, whatever you're entitled to take recourse to, that liberty
Lord,
you have.
Yes, Lordship will also see, my lord, they ought to have provided the report within 10 days. My lord, they have provided it us now, so my lord.
I am not into all that. I will simply say that they have done it, and in case you have any grievance under the law, you may take appropriate approach the appropriate forum in that regard. Simply that. You do whatever you want to do.
The limitation, but
That to anyway that is there.
they are providing us the report now.
Is there a limitation here for approaching?
Yes, my lord, because 90 days, my lord. Appeal section 18.
18.
Yes, my lord.
This is from recommendation.
Yeah.
What is the recommendation?
Lordship, kindly see, my lord, this is a report under subsection 2 of section 13, my lord.
2 of 13.
Subsection 13.
Inquiry report.
Yes, my lord.
2 of subsection 13.
Yes, my lord. Because they have not found guilty.
It shall recommend. So against this, an appeal lies. And that appeal is how much time?
90 days.
90 days. Now this was served upon you on when?
Last occasion, my lord, 31st October.
So you have 90 days time.
Yes, my lord. So my lord, from the date of order actually. So the copy has been provided to us only on 31st.
So no court inferior to that of a metropolitan magistrate or a judicial magistrate of first class shall try any offense punishable under this act. Okay. Where is that recommendation last time you had given? Yes, this one, the minute.
Yes.
5625, na? Heard Mr. N.K. Kalita, learned counsel appearing for the petitioner. Also heard Mr. I. Thakur, learned counsel appearing for the respondent numbers 2, 3, and 4. And Mr. And you're also the MS? MS? You have a name, ma'am. Pallavi? Nath. MSP Nath, learned counsel appearing on behalf of Mr. J. Goswami, learned counsel for respondent number 5. P. N. Sharma, respondent number 1. Sabarahi, sir. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking reconstitution of the internal complaint committee as per provision of section 4.2 of the Sexual Harassment of Women at Workplace within bracket Prevention, Prohibition and Redressal Act of 1913. Stop.
2013.
2013, huh? In the instant writ petition, along with the aforesaid direction, the petitioner is also seeking direction to the respondents, more particularly the respondent number 2, 3, and 4, to take necessary steps as per guidelines and norms prescribed by the Honorable Apex Court of India and the Act of 2013 for redressal of the grievances of the petitioner and for imposing penalty upon the respondent for non-compliance of the provision of section 4.2, 11.4, 19 of the Act of 2013, and for setting aside and quashing the notice dated 22/3/2023 constituting the internal complaint committee. Stop. During the pendency of the instant writ petition, an instruction dated 5/6/2025 has been placed before this court on 31/10/2025 by Mr. I. Thakur, learned counsel appearing for the respondent numbers 2, 3, and 4, which is available on record, which has been taken on record and marked as X, whereby it is seen that the complaint committee has been reconstituted to conduct an inquiry on the complaint submitted by the petitioner, and the said reconstituted committee, after obtaining the statement from the petitioner and from her few colleagues, has submitted its finding and has also recommended further course of necessary action. Prima facie, that being so, the grievance raised in the, and that being so, the primary relief sought in the instant writ petition has already been has already been done. Has been done. Stop. As regards the grievance submitted by Mr. N. Kalita so-and-so against the recommendation of the said reconstituted internal committee, it appears that an appeal provision is provided under the Act 2013. As regards the penalty as regards the imposition of penalty contended by the petitioner, it appears that under section 26 and 27 of the Act 2013, in the event there has been non-action under section 13, which is alleged in the instant writ petition, correct? 13, non-action, comma. The Court of Judicial Magistrate First Class is competent to try the said offense. In view of the above, the prayer considering that the internal committee prayed for constitution of the internal committee as prayed for in the instant writ petition has already been constituted and the same has already submitted its recommendation, nothing survives for adjudication in the instant writ petition. However, in the event the petitioner has any grievance against the recommendation of the internal committee so constituted, the petitioner is at liberty to file appeal under section 18 of the Act so and so. And in the event such an appeal is being filed, the 90 days period shall not shall come this is not required because the statutory thing. You see, you still have the time.
No, my lord.
The appellate authority shall keep in mind that the aforesaid recommendation was only served to the learned counsel appearing for the petitioner on 31/10/2025 when this court was listed before this court. I will just simply say that, okay? Needless to clarify that that the petitioner is further at liberty to approach the competent forum for by way of a complaint.
That complaint part will not come because if internal committee found him guilty, then only complaint will
No, because you say penalty for non-compliance.
Penalty only 26, that
See,
is
no.
other aspect.
No, that is not other aspects. You see, Mr. Kolita, my understanding is 26 and 27 has to be read together because 26 says where the employer fails to take action contravene, okay, he shall be punishable with fine, which may extend to 50,000 rupees. Now, if you come to 27, no court shall take cognizance of an offense punishable under this act.
Yes.
So punishable under this act means 26 also? Punishable, correct? Or any rules made thereunder, save on a complaint made by the aggrieved women or any person authorized by the internal committee or local committee in this behalf. Is a penal provision. It has to be given by a court. You see, no court inferior to that of a metropolitan magistrate or a judicial magistrate of the first class shall try any offense punishable under this act. So if you are saying 26 comes, which is a punishable offense, it has to be tried before the criminal court. under 27.
My understanding is little different.
No, this is very clear.
I may be
So
wrong.
do you want me to put this or you don't want me to address on the penalty issue? Kibili likhila? No. Needless to be clarified that the petitioner is at further liberty, if so advised, to take recourse to appropriate remedies as provided under law for non-compliance as canvassed in the instant writ petition. Non-compliance of the provisions of the Act so and so as canvassed in the instant writ petition. So if something is there, you examine, you do it. You see, penal provisions cannot be given by just like that by someone. It is an offense, punishable offense.
All right.
And 27 says it. Disposed of.
May I please your lordship? Lordship, in this case, my lord, respondent number 1 already retired and respondent number 2 already died, my lord. So kindly, my lord, the
You have to
two
bring the new
incumbents-
incumbent.
Yes, my lord.
It's a 2016 matter.
My lord, they are all.
And you are for whom?
And actually, all these matters are earlier handled by Honorable Mr. Justice R. Muzumdar.
No, you don't have to refer to all that. Another set of counsel was there. But you see, even if you have newly engaged, where are the contemners? They don't get automatically discharged. The death is different, but the other person, he is there.
He's already retired.
On the last.
They have
occasion-
retired, but this is a contempt. He's named here by person, not by the post he is holding. It's a contempt proceeding. What is the use of arraying contemners by name then? They cannot be automatically discharged. It's a 2016 matter.
My lord, already both the petitioners accommodated, my lord. Newly accommodated, my lord.
Is it correct? Have your instructions because if it is compliant.
Yes, my lord. Already they were accommodated as a tutor, my lord.
22, 2210.
25.
Where is Mr. B. Kaushik? He was supposed to obtain instructions.
He's on wait, sir.
So this is the instruction that they have been accommodated.
Yes, ma'am.
She has got her instructions. You find out.
Yes,
And
ma'am.
in the event it is not compliant, then you get the new incumbent also because the matter, otherwise, in the absence of the new incumbent, it may not be able to proceed. You may not.
Basically, case is relating to the non-payment of salary.
So that I think is done. So you have a look at it.
Her submission to the
What is exactly your submission? Heard Mr. J.I. Barbuyal, Learned Counsel appearing for the petitioner. Also heard MS N. Fukan, Learned Counsel appearing for respondent contemner number
1, 2, my lord.
1 and 2.
Yes.
Who died?
Sanjeev Bhuya, my
No,
lord.
2 died or 1?
2 died.
Then how can you appear for 2? 2 is not there.
Respondent 1.
For 1. Stop. So and so submits that in the meantime, respondent number 2 has expired. Contemptor number stroke respondent number 2 has expired. She further submits that the contemptor so and so has also in the meantime retired. She further submits on instruction that, yes, now tell me.
Both the petitioners are accommodated, my lord.
Accommodated
as
for
a
what?
Tutor, my lord.
That both the petitioners have been accommodated as tutor.
Yes, ma'am.
Where?
It-
As tutor. Stop.
Yes, ma'am.
However, no written instruction or any response. Nothing has been filed, na?
No, man.
No response.
My case is only for
Nothing has filed, right? No response has been filed pursuant to the show cause issued by the contempt court. The matter being
Well, on Friday, my
the
lord.
matter pertaining to contempt jurisdiction, it is deprecated the deprecated that this matter has been pending since deprecated in the manner in which the contempt proceeding has been pending in this court since the year 2016. That too, huh?
15.
The registration is 2016. Please don't disturb the flow of the court's order.
Sorry, my lord.
Be sure if you have to correct something. কি লিখিলা? That too without the contemners putting the response in terms of the show cause issued by the contempt court. Be that as it may, relist on,
After 1
give a date. You just said Friday, now we have gone to a week.
10 days after, my lord.
And a date, on such and such date, let specific response by respondent number stroke contender number 1 be filed before this court by the next date of listing. In the meantime, Mr. So-and-so Barbhuya, Learned Counsel for the petitioner, is at liberty to take appropriate, to do the needful to bring the new incumbent to the aforesaid, to the post in questions, if so advised.
12 is also same, my lord.
Till 12,
Same.
11.
for hearing item number 14.
Can you put as
Wait, please, your lordship. Not heard the matter.
Yes, I think I will just dictate the judgment. I have already heard you all.
Lordship, there are
Yes.
two questions that was left, my lord. One was the multiplicand, my lord.
What
think-
multiplier?
Lordship, may kindly see the Pranayasati judgment for a moment.
No, first tell me in the ground, where have you taken this tent?
Lord. Let me look over it.
In the appeal memo, where have you taken
Lordship,
that ground?
Lordship, we are coming to this. Page 7, my lord. Ground number 5. For that, the correct
One
multiplier.
second. Page?
Page 7, my lord.
Yes.
For that, the correct multiplier would be 18 and not 13 as held by the learned member Motor Action Claim Tribunal.
Ground number?
5. Ground number 7 is with interest. Rate of interest with 12% and has to be abated from the date of the filing of the.
Why 80, would
That
be
is the-
18?
It was settled by the constitutional bench. Okay,
Sure.
I've given the copy of the judgment. Lord.
Yeah.
Lord, kindly put up, Lord. Okay.
Yes, which paragraph?
Lord. Paragraph number 59.2 million.
59
59 Lord.
point?
59. We start from 59. Let the whole conclusion, Lord, of the MSC cases, page 28.
এটা তো আমার আসিলে, no? National.
Lordship has 59 Lord. In view of the.
One second. Yes.
In view of the aforesaid analysis, we proceed to record our conclusions. The two judges bench in Santosh Devi should have been well advised to refer the matter to a larger bench as you are taking a different view than what has been stated in Sarla Verma judgment by a coordinate bench. It is because a coordinate bench of the same instance cannot take a contrary view than what has been held by another coordinate bench. As Rajesh has not taken note of the decision of Resma Kumari, which was delivered at the earlier point of time, the decision is so is not a binding precedent. While determining the income, first addition has to be done. In an addition of 50% of the actual salary to the income of a deceased, what future prospect where a deceased has a permanent job. And
So
the
this multiplier is for the income composition.
composition.
Income composition. So if suppose, because this quote was because as all of you on that date was has come to a almost to a consensus that yes, the ITR was not taken into account, which ought to have been taken into account by the tribunal. Now that is why the course that this court was thinking of adopting is to send it for that part, because the ITR does not indicate that figure. You tell that it comes to so and so, but that has to come through evidence. So I was supposed to send it back only to that limited. So I may add there by applying the correct multiplier in terms of so and so. So that part only, not without disturbing the rest of the part of the judgment, I'm going to adopt that. Because you see that income tax that you are saying does not indicate the annual gross income figure. It is giving something else.
No, Lordship takes up that.
There is the clarity is not there, Mr. Lal.
Lordship.
Your ITR does not have that clarity.
Yeah, but whatever it is.
That so I am not rejecting.
Lordship.
I am not rejecting. That should have come. The letter certificate be called from the income tax auditor or whatever, that the trial court do it within a specific period of time. It will come, because there is a way of doing it that is not clear, Mr. Lal. I am not rejecting your
I
thing.
understand, Lord. But Lordship should appreciate me, Lord.
And I will add this part also
Lordship,
by applying the correct multiply in terms of so and so judgment.
Lordship may appreciate two things, my Lord, here. One is it's a matter of 2012, my Lord. And
So that means without evidence, this court is going to now accept that ITR.
No,
That ITR is not clear. The clarity is not there, Mr. Lal. This court is conscious. If that income tax, there was also something more saying that what is the amount you said after the ITR, it comes to 4,000, 5,000 something you said, right?
13,000 something.
Correct. Where is that figure?
Lordship,
Please show me that figure in the ITR.
look, ITR is always filed.
Please show me that figure.
My Lord, may kindly take the ITR. my
No,
Lord.
it is not there. And this court is not an expert.
No, may not.
So that has to come
But
from an
if-
expert, Mr. Lal. Anyway, Mr. Lal, you won the judgment. I'm giving it right now. Otherwise, I am adjourning it. Because this matter cannot go on prolonging. This court has already decided. Because there is no clarity. If there was a clarity, it was another thing. Of course, this court can also do it. But there has to be a clear figure. That's why on the last occasion, I asked you 3 times.
Yes, Lord.
You've been saying that you calculated it like this.
No,
Anyway, I will take
Just-
care of that. Yes.
my Lord, the difficult part would be that after 2012, we will not get the income tax return from the department.
That's all right. You don't need someone from there. You need an expert to just give that opinion.
That's
That an expert has to give that opinion. I'm not, this court is not an income tax expert.
Lordship should observe that, my Lord. That
I
should
shall
be-
take care of
take
that.
note. Lordship, now,
The matter stands closed. I'll give the judgment inside.
Lordship.
Yes.
Lordship, there is a note that I have prepared, my Lord, in the matter.
Give.
That's an argument, Lordship. There was 4 aspects of this, my Lord. Interest part was also there, Lordship, but we have.
What is that on interest you were saying?
The interest has to be from the date of the filing of the claim petition, my Lord. And normally the interest that is being granted is 9%, my lord. No, in normal course, my lord. That's what my solution.
You have not been given from the date of filing the claim petition. Where is it that it has to be from the date of filing of the claim petition?
My lord, it is settled position of the.
Where is it? Where is it? Because as per 9% or 6%, that is the discretion.
That is the discretion, not it.
Is it set, it has to be from the filing of the claim petition? Is
It
it,
is from the filing, date of the.
you agree to that?
Generally,
So I will say then since I'm going to remand it only for that limited, so I will say interest so and so from the date of filing of the claim petition. But I'm not changing the rate. 6%, the discretion the tribunal has already exercised. This court doesn't find anything to interfere with that discretion.
These are the judgment, my lord.
Sound reduction. To yate lekhai diu ni. Better hoga na.
First judgment, Kia Tandon case, my lord. 1998, 8 SCC to 421.
You don't need so many. If it's a settled law, give me one.
One. That's
Mr.
first.
Lal, settled law means settled.
That's
So now please show me the paragraph. Where is it settled?
Paragraph 3, my lord.
Of which one? 1998.
1998. That's it. The tribunal has, the tribunal has awarded interest at the rate of 6% per annum from the
All
date
right,
of the
fine.
award. But I put you to topic. Lordship reads very fast, my lord.
Please take your seats.
Sir.
The difficulty is that if one is slow also, you all have grievances.
No, no, I
If
don't
one
have
is fast
grievances,
also,
my
you
lord.
all have grievances. Now what should the court do? Tell me,
No,
Mr.
sir.
Lal. You want
It is
disposals
not-
also?
No, no, it is not grievance, my lord. It is appreciation, my lord. We cannot
Yes.
try to.
Heard Mr. A. Lal, Learned Counsel for the appellant. Also heard Mr. K.K. Bhattana, Learned Counsel appearing for the respondent insurance company. This appeal under section 173 of the MV Act 1988 is directed against the judgment and award dated 13/2/2017 passed by the Learned MACT 3 Kamrup Metro, Guwahati in MAC case number 2122/2012, whereby the tribunal, while allowing the claim petition, assess the monthly income of the deceased at rupees 4,000, right?
4,500, my lord.
4,500 and awarded a total compensation of rupees 6,36,500 with interest at 6% from 2/9/2015. Correct? Stop. The claimant stroke appellant seeks enhancement of the award primarily on the ground that the tribunal failed to properly assess the income of the deceased. Stop. It is contended that although the claimant produced both a salary certificate and income tax returns within bracket ITRs, 2 ITR was, I think, there. Two were there, right? Of the deceased, the tribunal rejected the salary certificate for want of proof and did not take into account the exhibited ITRs while determining the income. Stop. The deceased, I. Karan Singh, son of the claimant, died in a road traffic accident on 27/10/2012 near Dharapur Petrol Pump, NH37. After being hit by a Maruti 800 car bearing registration number AS-01/K-8841. The claimants accordingly preferred the compensation case before the tribunal. Stop. The deceased, son of the claimant, was working as an electrician in a private hospital, earning about rupees, what was that exact amount there? 5,000 something.
5,299 lots.
5,299
page 68.
5,299 per month as reflected in the salary certificate produced and exhibited along with the claim petition. Produced along with the claim petition. The claimant further deposed that the deceased was also engaged in additional electrical works during the free hours. During his free hours. Stop. The claimant further exhibited two income tax returns. Just see the descriptions. ITR 4 and ITR 5 for the assessment years 2010 and 2011 to 12, marked as exhibits 6.1 and 6.2 respectively. These returns, bearing the acknowledgement and seal of the income tax department, clearly indicate that the deceased was an income tax assessee. The tribunal, however, rejected the salary certificate on the ground that it was not duly proved and without adverting to or discussing the exhibited ITRs, assessed the income notionally at rupees 4,000.
4,500.
4,500 per month. Stop. Heard the learned counsels for the parties and perused the materials available on record. The question that arises is whether the tribunal erred in failing to consider the exhibited ITR, full form ITRs, while determining the income of the deceased, and whether the matter should be remanded for limited verification and reassessment. The other day you had given some decisions on statutory. You had given, right, some decisions?
Statutory documents.
Yes.
And that was, we have marked it in the written argument also.
You've marked it?
Marked in the written argument. If Lordship takes up Page number 6 of the written argument, my lord.
No, I've actually marked it.
And we have the extra copy also, my lord.
1 second, 1 second.
And the-
एक नहीं असल नहीं है. The main apex court decision was which one? Sangeeta Arya.
Sangeeta Arya case, my lord. From Kalpana Raj, Sangeeta Arya and Malvez, my lord. Yes. Malar Bridge, my lord.
Just
This is a statutory document.
one is Sangeeta Arya, then the other one is
One is Sangeeta, the other one is Malar Ridge, my lord.
that I have.
24 SSC.
Yes, that I have. I have. 1 second. Just give me the names and I'll sort it out because you give so many citations.
No,
Yes, which is the other one?
2020, my lord. 4 SSC, 220 Malar Ridge, my lord. And
Malar.
Malar.
Yes, then
Then Kalpana Raj, paragraph 8.
Kalpana.
Kalpana Raj, my lord. 2015, 2 SSC, 764. Kalpana Raj, paragraph 8, my lord.
Raj. Okay.
Sangeeta Arya, photocopy was there, my lord. Sangeeta Arya case.
Yes, I have it. It is well settled that income tax returns are statutory documents filed before a competent public authority and carry a presumption of correctness unless proved otherwise. In Sunil Sharma versus so and others, reported in 2011, volume 11, SSC 425, the apex court held that the income disclosed in the income tax return filed by the deceased during his lifetime is a statutory declaration which can safely be relied upon to assess income in motor accident claim proceedings. Likewise, in Malarvi and others versus United India Insurance Company Limited, reported in 2020, volume 3 SSC, at page 21, the apex court reiterated that even certified photocopies of income tax returns can be relied upon in motor accident claims, and that strict rules of evidence are not to be applied in summary proceedings before the tribunal. Paragraph 10 to 11, na? Mallarvizi, paragraph 10 and relevant paragraphs of the aforesaid judgment reads as under quote unquote 10 and 11. 10 and 11 did. Similarly, in Sangeeta Arya and others versus Oriental Insurance Company Limited and others, in 2020, volume 5 SSC 327, the apex court held as under para 13, quote unquote. Similar principles were reiterated in Oriental Insurance Company Limited, Dio Patadi and others, reported in 2009, volume 13, SSC 123, Lakshmi Dev Verma versus so-and-so, reported in 2015, volume 4, SSC 264. One has been, Kalpana is there, no? Then Kalpana Raj and others versus Tamil Nadu so-and-so, reported in 2015, volume 2, SSC 764. Wherein it was held that ITRs being statutory documents constitute reliable proof of income unless shown to be fabricated. In the present case, though the ITRs exhibits 6.1 and 6.2 were exhibited, the tribunal completely omitted to consider them while assessing income. Where is that finding about the salary certificate?
Page 101, Lord.
Page
101 of the paper book.
101
One of the paper book.
of the paper book. No,
Judgment is there.
in the judgment?
Judgment is also attached in the paper.
Where? In the appeal memo, it's not there.
Appeal memo is also there.
You-
Last appeal memo, Miller, it will be page number 17, Miller. Paragraph 19.
Okay. কি লিখিলা? The rejection of the salary certificate issued by the concerned hospital merely on the ground that the authority of the said hospital is not before the tribunal to prove the same could not have justified ignoring the ITRs, which are statutory records independently admissible under Section 35 of the Evidence Act, being entries in public document. The omission to consider such material evidence has resulted in an erroneous assessment of income. Stop. Even though the ITR acknowledges do not clearly spell out the exact gross total income, their existence establishes that the deceased was an income tax assessee thereby indicating that his income was higher than the meager notional figure of rupees 4,500 per month adopted by the tribunal. the Supreme Court, the Apex Court in National Insurance Company Limited versus Keshav Bahadur and others reported in 2004, 2 SSC 37 held as under quote unquote para 10. Reading of the aforesaid paragraph of the aforesaid paragraph, comma, it is apparent that where the material before the tribunal is inadequate for a proper assessment, the appellate court may remand the matter for limited reconsideration. Likewise, in Raj Rani versus Oriental Insurance Company Limited, reported in 2009, volume 13 SSC at page 654, held that the High Court has ample power under section 173 of the Act to either reassess or remand depending upon the sufficiency of evidence. In the circumstances, since the tribunal rejected the salary certificate and failed to consider the exhibited ITRs, this court finds it appropriate to remit the matter to the tribunal for limited verification of the income of the deceased with liberty to the parties to adduce additional evidence confined to that issue. It would be worthwhile to mention that the the enhancement has also been sought under the instant appeal in the instant appeal on the ground that the tribunal committed an error by applying the multiplier 13 on the basis of the age of the mother of the deceased instead of the age of the deceased, and that the claimants are entitled to interest at the rate of 9% from the date of the filing of the claim petition till payment. Mr. So-and-so learned counsel for the respondent insurance company fairly concedes that as regards the interest from submits that fairly concedes that it is well settled law that interest should be from the date of the filing of the claim petition till payment. However, he submits that the fixation of the rate of interest is the judicial discretion of the tribunal. Correct? No. Accordingly, Mr. Lal, now you hear the operating part. I want to add that multiplier also. Accordingly, while affirming the finding of liability and other conclusions of the tribunal, this court remands the matter to the tribunal for the limited purpose of verifying and determining the actual annual income of the deceased by taking into account the exhibited ITRs within bracket exhibit 6.1 and 6.2, calling for clarification or certification from the concerned income tax department regarding the total income reflected therein and permitting both sides to lead additional evidence, oral or documentary, confined only to the issue of income. Upon such verification, the tribunal shall recompute the compensation in accordance with law by following the correct multiplier and granting interest from the date of filing of the claim petition till payment. Instead of saying this, can I not say in terms of Sarla Varma? In terms of Sarla Varma, will take care of it.
Yes, Lord.
एखिनि कोआ जगत, following the principles laid down by the apex court in Sarla Varma and others versus DTC, reported in, you have given that, na?
Yes, Lord. 2009 6 SSC
2009 volume 6 SSC 121 and National Insurance Company Limited versus Pranay Sethi and others, reported in 2017 16 SSC 680. Within 3 months, 3 months from the date of receipt of certified copy of this judgment, the remand is confined solely to the issue of income. All other findings of the income.
Income multiplication, Milord.
Needless to be clarified that the tribunal, while recomputing the compensation, shall in addition also adopt the correct multiplier and grant the 6% interest as awarded from the date of filing
Of the claim.
the claim petition till payment. The remand is confined only to the issue of income, comma, multiplier, and interest. I don't think I have to say. To the extent indicated above, all other findings of the tribunal shall remain undisturbed. The appeal is accordingly allowed in part. The matter is remitted to the tribunal to the extent indicated above for limited verification of income and recomputation of income by adopting the correct. Return the TCR.
Lordship, kindly take care of paragraph 22 of the influence judgment. Paragraph 22 of the.
The liability will be on the insurance company. The liability of payment will be on the insurance company, Milord. That has to be covered.
In the influence judgment, the tribunal directed the insurance company to recover from the owner. However, while the matter was remanded earlier, the judgment has attained finality that the liabilities of the insurance company and not of the owner.
Liabilities of the?
Insurance company and not of the owner.
That is already taken care of. I don't think I need to clarify anything.
Just to mention, Milord, because
Mention what?
that the liability to pay will be on the insurance company, Milord.
Paragraph last page 18.
The finding will remain the same, Lord.
I have already said. So that finding will remain. Then?
No, Lordship has not said that the direction to pay will be on the insurance. The liability will be on the insurance company.
1 second. I am not following what you're saying. Just 1 second. Paragraph 22 of the judgment.
Next page.
The OP insurance company is directed to release the amount within 1 month. So that you will now do after the recomputation.
Lordship, I am for the respondent number 1.
Yes.
Owner cum driver.
And who's the insurance company is them? So what do you want, ma'am?
Lordship, the matter was remanded back earlier and on the matter of driving license, the violation of driving license, and it has attained finality the judgment of dated 15 to 25, where the insurance company was made liable to pay to the claimants and not the
Driver. So give me that. Eto ko but add kore dib, huh?
Lordship may kindly see paragraph 35 and 36.
It would be mentioned that
Paragraph 35 and 36.
1 second. that upon an appeal filed by the owner cum driver stroke respondent number, in this case, our respondent number 1, before this court by MAC appeal number 373 of 2017, the judgment of the tribunal dated 13/2/17 was remanded back, paragraph.
35 and 36 is the operating part.
So this court had remanded it back, remanded the matter back to the tribunal on the limited ground of fixing the liability on the limited ground of examining the validity of the driving license of the appellant stroke owner cum driver of the vehicle. Correct? Thereafter, upon remand, the matter was heard on 15. The matter thereafter, upon remand, the tribunal by order dated 15/2/2025 held that the driving license of the OP number of the respondent number 1 stroke appellant was valid as on the date of the accident on 27/10/2012, both on the count of the validity date mentioned in Exhibit F, regardless the date mentioned in the official record of DTO Kamrup. And hence, no infraction stroke violation of the policy condition. Correct? And accordingly directed the insurance company stroke OP number 2 to pay the compensation amount along with interest as ordered by this tribunal to the claimant stroke respondent number 1 within 30 days from the date of the said order. The findings of the so and so shall remain as it is. However, the insurance, you have not paid anything till now.
No, that tribunal award has already been paid.
So that has been paid. Then I don't think I need to say anything else.
Only two places. One, Lordship may kindly fix a date for the appearance of the parties before the tribunal.
That
Second-
I will say once the notice or when you want to want, because this records has to go there.
After 1 month, Lordship may kindly fix it. Otherwise, I will again have to take notice. They have to go, and it will take more than that time. After 1 month, Lordship may fix a date. And second thing, Lord, it is only for the
Correct, I have indicated, Mr. Lal.
No, Lordship, it will create problem in the trial court.
It will not. I have said in so many words I have clarified, very limited ground only for the purpose of verification. Do you want me to keep repeating that in paragraphs after paragraphs?
Not only verification should be clarification.
Tribunal will fix it. Correct. So I will add a word that upon receipt they will, and in any case I have given a 3 months time for the entire.
Lordship does not fix a date before.
All right, Mr. Lal, I'll take care of that.
Lordship. And Lordship, verification with clarification, if it does not come, it will create problem. We'll come back to your Lordship only, next time.
I don't think, Mr. Lal,
Lordship.
you have you read the judgment one, you get it.
I am obliged, Lord.
বস্তু আছে দেই এটা তুমি এইখিনি সব বেয়া হাতত দি দিয়ক হা
Item
16.
এখানে আসিলে দেখুন কে কে ভাত্তা He just left. Mr. Bhatta, I think this is your appeal 16. Is this not yours? National Insurance Company.
I get what 20 is mine.
No, not 16. None appears for in 16. None appears on call. Released. Mr. S.P. Chaudhary, Learned Counsel for the respondent is present.
Probably RK Patra is there. I said from
Hmm?
RK Patra.
Is it R.K. Batra? Because reflected is K.K. Bhatta.
RK Patra.
Who is there, Mr. Chaudhary? Who is the counsel appearing for the respondents?
Probably the here of the last.
No, but otherwise, who's there on record? Just see if the correct name is not reflected, maybe because of that, have a look at it. It all up is a type word.
And RK, my learned friend is saying about RK Patra.
Have a look at it. Call the next matter in the meantime.
Item number 17.
Yes, Mr. Chaudhary, dismissal.
Disciplinary proceeding matter. This was again, my lord, heard at length, reserved thereafter. This is again likely to take some time. I'm leaving it to your lordship, otherwise I'm prepared, because the other matter is parted, which is coming up day
At
after,
2.
day after tomorrow. So that is also likely to take some time. If
In
this
fact,
also gets,
at 2 also there is a part heard that has been specifically fixed.
in that case, my lord, let the other matter be over on 6th. I mean, day after tomorrow. After that, this can be fixed. Because this is also likely to take some.
Say a date then. Because this matter otherwise was also once heard, right?
Heard, reserved.
Yes, I have seen the noting. Yes, come up with a consent date. Heard Mr. I. Chaudhary, Learned Senior Counsel, assisted by Mr. T. Das. T. Das, right? Learned Counsel for the petitioner. Also heard Mr. S. Nath, Learned Counsel for the respondent numbers 1 to 4. Aspirate for relist on such and such date.
4th of December.
4th
It's a
of
Thursday.
4th, so and so.
I'm like,
Yes,
Excuse me, although I signed in the Galat.
your name, yes.
Because it is the case of.
So are you there or not?
No, I'm not there.
He was not the impanel advocate at that point of.
At the time, Lordship, I was not there, Lordship. I shall inform my assessor.
So then that is why, because you see, you inform whoever has to appear. Otherwise, it will go on. I'm going to, this matter is getting fixed time and again, but because the
I shall inform.
the name. Anyway,
It does not even, I shall appear. in the
okay,
next-
okay. SP Chaudhary Dila. Mr. K.K. Bhatta, Learned Counsel, whose name is reflected in the cause list for the appellant, informs that he is been wrongly. He that he is currently not the. Are you still the setting counsel of national?
Setting counsel of-
At that point of time, he was not there. He was
at-
under
at
the
that
senior.
time, I was not there.
That then how did your name come?
Exactly.
Then I was a junior, say, assessor.
Signature is there, Lordship, in the Wakalatnama.
But then your name is there. You have signed the Wakalatnama, Mr. Bhatta, and you are still there in the national company. So you please take our instructions. I will
Exactly, he
record
can
your
appear.
presence.
Exactly.
I
he can appear.
said, take.
Your once you have signed the Wakalatnama, your obligation. This court cannot ignore your obligation. Neither can you ignore your obligation unless you take appropriate steps to struck off your name or something.
Next time, I.
Lordship may fix a date in the next.
Yes. Heard Mr. K.K. Bhatta, Learned Counsel appearing for the appellant. Also heard Mr. S.P. Chaudhary, Learned Counsel for the respondent. Mr. Bhatta seeks a short accommodation since at the time of since though his name though he is on record, but however he was led by Mr.
Assessor.
S.S. Sharma at that relevant point of time, and accordingly stop Korea. Relist when after?
After a week, Lordship, next.
Give a date on such and such date.
11, 12.
Yes.
14.
14. All right.
Item number 15.
Lordship, in this case, K. Gogoi is applying for the higher education lordship. And I talked to him, he says that they can proceed.
No, we will not hear in a piecemeal manner. It's a, okay, what, regularization?
Yes, yes.
Mr. Sikdar?
Yes.
Regularization, yes, so where is Mr. Gogoi?
He said he'll come, Lordship, and they will start and he'll join Lordship. That's the instruction, Lordship.
If I, Lordship, permit to start, I'll have to start.
So that is no difficulty in starting, but if the counsel for replying is not here, it's difficult.
Yes.
I don't want to get stuck after investing judicial time in the matter.
Yes.
There are more
My lord.
hearing matters on
My
board.
my lord.
So then when Thursday or Tuesday?
Tuesday की 12 तारीख है 11
That's prayed for list Tuesday,
Yes.
did you?
Tuesday the 11 ना 11 maybe
Good.
no problem.
Item 19.
Yes, Mr. Paul.
May I please, Lordship, I'm not well. I'm not well.
Apparently, Mr. Paul, almost everyone is because of the weather, the
Yes,
change.
because yesterday I come.
No, that's all right.
I was in the early in the
Yes,
morning.
yes, all right.
But 13th, if we accommodate 13th of this month.
All right. As prayed jointly by the parties, relist on.
13-11.
All right.
Much obliged for hearing.
20.
Yes, Mr. Bhatta. Insurance appeal.
In this case, two vehicle was involved in the accident. As per evidence on record, both the vehicle was responsible for the accident. But entire liability was fastened upon the insurer of one vehicle, of it. That is why we filed it. It is a case of DDNT. No police case was registered as per.
So two vehicles was involved
That's it.
and
One-
two different insurance companies.
Yes, sir.
And liability fastened only on one insurance company.
That's-
Why?
That is why we filed it.
No, what is the finding?
Finally, also can you see the page number 10 of the judgment of it? Issue number 1 and 2.
The other insurance company was a party or not?
Yes, yes.
You are appearing for the other insurance. And you are the claimant, Mr.
Yes.
Talukdar, na?
Yes.
You are for the claimant.
Yes.
Yes. Page.
Page 10,
Yes.
issue number 1 and 2.
Yes.
Both issue number 1 and 2 are taken up together for discussion as the both were interrelated to each other. CW1, the claimant in the instant case has executed.
And another vehicle. So two vehicle. Now, which is your, you are the insurer of which vehicle?
And the insurer of the, let's say,
5429 or, no, that's same vehicle.
Yes, Lordship.
1286, huh?
Yes,
He's
purpose
for
actually the
I am for the truck.
truck 1286.
Yes, Lordship.
Okay. You are respondent number 2,
Lordship, I am for 6.
R6.
Yes.
Who are the R125? All claimants, 125.
only one is the claimant.
Only one.
And who's appearing for the 2, 3, 4, 5?
No one is a pair. Let's say all the.
Who are they?
Services completed, let's say.
Who are they?
Let's say who is the owner of the vehicle, owner of the bus? He is the driver of the bus. Who is the owner of the truck? And 5 is the driver of the truck.
Surveys have been deemed complete about the, which order? I'm trying to find that order. Yes, in view of the office note, service is complete. Okay, page 10, yes. Make your submissions, I'm hearing the matter.
Let's kindly see the issue number 1 and 2.
Hmm.
Both issue and 1 and 2 and taken up together for
Yeah, okay.
discussion as both the issue are interrelated to each other. CW1, the claimant in the instant case, has exhibited the accident information report filed Exhibit 1. Exhibit 1 was issued by OC Jokalabanda Police Outpost. As per the accident report, Exhibit 1, the motor vehicle accident took place on 12/10/2018 at around 6:30 p.m. at Deosar RCC Bridge near National Highway 37. The 709 bus bearing registration so-and-so was involved in the said accident as per the Exhibit 1. OP number 2, Dilu Bhia, was the driver of the said offending vehicle. At the time of accident, he was a valid driving license number so-and-so, which was issued by DTO Nagaon. The opposite party number 1, Srimati Deepika Soikia Kyaut, was the owner of the said offending bus. At the time of accident, the said offending bus was insured with the opposite party number 3, New India Insurance Company Limited. The police has registered the case filed Jokalabanda PS GTNT number 246 dated 12/10/2018. The opposite party did not challenge the content of Exhibit 1. The accident information accident report during cross-examination of CW1, which the claimant in the instant case. According to the evidence of the CW1, on 12/10/2008, while he was traveling the said offending bus, bearing number so-and-so from Golaghat toward Banga side on the national number 37, when they reached at their shore RCCBs, the truck bearing number so-and-so coming from the said direction, in a rash and negligent manner, after the said bus from behind in a dead course. So as per the evidence on DW1, the truck bearing registration number so-and-so coming from the side, the said direction in a rash and negligent manner and knocked down the said bus from behind in a great force, and in a result, the claimant sustained grievous injury on his person. The driver of the bus number suddenly applied the hard brake on the middle of the road, and the truck coming from the backside and dashed against the said bus from behind, in the result which the claimant sustained grievous injury. The OC Jokalabanda Police Station did not implicate the owner and driver of the truck number so-and-so in the accident report Exhibit 1. Only the bus number so-and-so and is the owner driver had been implicated in the accident.
So only one has been implicated.
Implicated.
Your bus.
Yes.
So it was a bus and truck involved. You are the bus.
Let's kindly see the.
Oh, no, anyway, let's go on.
Let's kindly see the page number 14.
We will go. Let's complete. Just carry on.
The driver of the bus number so-and-so suddenly applied the brake on the middle of the road, and the truck number coming from the backside and dashed against the said bus from the behind, and in the result of which the claimant sustained grievous injury. The OC Jokalabanda Police Station did not implicate the owner, driver, and the truck of the accident report Exhibit 1. Only the bus number so-and-so and its owner and driver have been implicated in the accident report. Right, Exhibit 1. From the accident report Exhibit 1, we find that only the bus number is responsible for causing the accident that took place on 12/12/2018. Therefore, I find that the claim petition is maintainable and the proper cause of action, and the claim petition and the claim is entire documents so-and-so. That's it. Kindly see the page number 14. 2 ZDNT was recorded, let's say. On the basis of the ZDNT, accident information report was issued. ZDNT number 248. Now, SI HK Khaun, along with his staff, come back from the place of occurrence. The passenger injured was immediately transferred to Jokalabanda Hospital, and thereafter the pitch jam on Masonry has been cleared, and the vehicles were sent to proper place. Both the vehicle involved in the accidents were unloaded for taking necessary action. During the course of investigation, it reveals truck number so-and-so tried to overtake the bus bearing registration of so-and-so, and in the process of overtaking, the truck bearing registration number dashed against the backside of the bus, which was going ahead, and as a result, the bus substantially damaged and several bus passengers were injured. The injured person were admitted in Jokalabanda Hospital, and necessary entry was made. The name of the injured number was reflected.
Yes.
The police issued the accident information report on the basis of ZDNT number 248. As per ZDNT number 248, the truck was responsible, not the bus was responsible. But as for the evidence of PW1, both the vehicle was responsible. But learned
That
member,
was ignored.
yes, Lordship. But the learned member has considered that since the accident information report was implicated only the bus, that is why liability was fastened upon the insurer of the bus. But as per the evidence of the PW1, both the vehicle was responsible.
From 14, what you wanted to show, page 14, you were saying?
Putting the GD entry. No police case was registered, Lordship. Police case was not registered, only GD entry was recorded as per the.
And the eyewitness is the PW1,
Eyewitness is PW1.
the claimant.
Claimant.
Where is that evidence?
PW1 says that both the vehicle was responsible.
Where is that evidence? That evidence doesn't seem to have been discussed here.
Yes, Lordship.
Has it been discussed?
It was discussed.
Where? Which page of the PW1 in the judgment?
PW1.
Because here they have only talked about the GD entry.
CW1 on 12 when the while he was traveling the state opening bus bearing result.
Where are you reading from?
Page number 11.
Which part? CW?
When they reach at Deosor RCC bridge, the truck bearing registration coming from the same direction in a rash and negligent manner and knocked down the bus from behind in a great force.
Where exactly are you reading from?
What's it? Page number 5. 1, 2, 3, 4, 5, 6, 7, 8, 9.
About? Okay, CW1. Yes, according to the evidence of CW1, he is the claimant. While he was traveling in the said offending bus bearing so and so, when they reached at so and so, the truck coming from the said direction manner and knocked down the truck in a rash and so, knocked down the bus from behind a great force, and the driver of the bus suddenly applied brake on the beginning of the road and the truck. The police officer was examined. But that is only a document. How that police report, that GD entry is not evidence. It is not exhibited. Who exhibited the GD entry?
GD entry
Is not in the record, Lordship.
It's not in the
Not
record.
exhibited, not in the record, Lordship. Just along with the appeal, my learned can just file the photo statement.
No, but you see,
It is not the part of the record, Lordship.
no, but sorry, your name?
I'm sure.
Chaudhary. Miss Chaudhary, if we are at page 5,
Lordship.
now here there are two evidence that has been discussed, right? Now apparently CW1's evidence says both are responsible.
No, Lordship, the cross Lordship will find, he is the eyewitness. He himself said.
In the cross he says.
Yes, say.
Where do I get the
Lord-
cross?
Find in the lower court record, page 23, page
Please give me the trial court records. Can you give it to Miss Chaudhary? Miss Chaudhary, please, it's flagged. Just flag that evidence of CW1 and also if there is anything.
Page 20.
That's it. I can read the cross-examination part of the.
Just 1 second. Accident report is exhibit 1. That has, and that also you please mark there.
Yes.
Exhibit 1. That is exhibited by whom?
Exhibit by claimant. I can read the evidence of the PW1.
1 second, let me have it. You seem to be in a hurry, Mr. Mufta.
The statement of the claimant, Lordship, it is read by my learned and half only, Lordship.
All right, now you can read. Let's have the whole statement.
copy.
Ms. Bhatta, no, Mr. Bhatta, you have it. Let's read I so and so, the whole thing. Let's read the whole thing.
I can declare that I am the claimant of this present claim case. I filed this claim case for the injury sustained by me in a road traffic accident on 12/12/2008 at about 6:30 p.m. at Deosor RCC Bridge number 37 under Jokolabanda Police Station. While I was traveling from Golaghat towards Nagaon as a fare paid passenger in vehicle bearing registration number so-and-so bus, on our reaching at Deosor RCC Bridge under Jokolabanda Police Station, another vehicle bearing registration number AS09A1286 truck came from the same direction in a rash and negligent manner and knocked down the bus from behind with a great force. The driver of the bus suddenly applied hard brake in the middle of the road. As a result, both the vehicles damaged badly. The passenger of the bus also sustained injury on their person and body. I sustained the following injuries. I have submitted X-ray prescription, advice slip prescription, and case memos. That after the accident, I was immediately taken to the FRU Jokolabanda in a very serious condition. The attending doctor, after giving some first aid, referred to me. Possibly, it is regarding the injury. Then let's see. Cross-examination part. It is written in Assamese.
Read.
On 12/12/2008 তাৰিখে 6:30 গধূলি 6:30 মান বজাত মই 709 বাছেৰে গোলাঘাটৰ পৰা নগাঁওলৈ নেশ্যনেল হাইৱে নম্বৰ 37 বাছেৰে গৈ থাকোঁতে দ্বিতীয় RCC ব্ৰিজৰ ওচৰত পোৱাৰ লগে লগে আৰু দলঙৰ মাজ অংশ পাওঁতে অতি
Rash, I think.
কৰাৰ পিছত পিছফালৰ পৰা
অতি
গতি হ্ৰাস কৰাৰ পিছতে গতি হ্ৰাস কৰাৰ পাছত the bus was slow down. But গতি হ্ৰাস কৰাৰ পিছতে পিছফালৰ পৰা ট্ৰাকখনে খুন্দা মৰাৰ ফলত মোৰ ভৰি আঁঠুৰ তলত দুটাকৈ হাড় ভাঙিলে। প্ৰথমে জকলাবন্দাৰ ফাৰ্ষ্ট এইড লওঁ আৰু মই কোচবিহাৰ চিকিৎসালয়ৰ ডাক্তৰে
So he was inside the bus because the truck hit the bus from the back. He got hurt.
Yes.
Here, Lordship, this portion is missing, Lordship. The driver of the bus, Lordship, the driver of the bus number so-and-so suddenly applied the hard brake on the middle of the road. This portion is omitted, Lordship.
Where is that
It's
portion?
there, Lordship. My learned friend is just saying. This is page 11 also, Your Lordship will get. In the evidence.
I am reading the evidence part.
It is there, Lordship.
I am reading the evidence part, not
Yes,
the finding.
The driver of the bus number so-and-so suddenly applied the hard brake on the middle of the road and the truck number so-and-so coming from the backside.
Yes, it is there. The driver of the bus. This is in the chief.
Yes, Lordship.
No, but before we go there, no, you have to read the entire paragraph 1
Yes,
then,
sir.
correct? It says then I am the claimant of the present so-and-so, I filed so-and-so. While I was traveling from Golaghat towards Nagaon as so-and-so in vehicle, this is the 709 bus. This is the bus where he was traveling. On our reaching so-and-so, another vehicle bearing registration number 1286 truck, this is yours?
Yes.
Came from the same direction in a rash and negligent manner
Yes.
and knocked down the bus from behind with a great force. The driver of the bus suddenly applied hard brake in the middle of the road.
And the truck.
As a result, both the vehicles damaged badly. The passengers of the bus who sustained injuries on their person and body, I sustained so-and-so. Now you see, ma'am, we cannot go on interpreting words here. It is very clearly said that because a truck was coming from the back in a rash and negligent manner, that is why the driver of the bus had to press the brake. These are not my words. These are the evidence. In cross, he only says the subsequent part. Mr. Bhatta, just read that. Goti, what was it?
দিখৌ RCC ব্ৰিজৰ ওচৰত পোৱাৰ লগে লগে আৰু দলঙৰ মাজ অংশ পাওঁতে গতি হ্ৰাস কৰাৰ পিছতে পিছফালৰ ট্ৰাকে খুন্দা মৰাৰ ফলত মোৰ ভৰি আঙুলি দুটা হাড় ভাঙিছিল। And
Keep reading.
they also suggested
Keep reading.
প্ৰথমতে জখলাবন্ধাৰ ফাৰ্ষ্ট এইডত লওঁ আৰু মই কোচবিহাৰত চিকিৎসা লোৱাৰ কোচবিহাৰত চিকিৎসা লোৱাৰ ডাক্তৰী কাগজ পত্ৰ দাখিল কৰাওঁ। মই চিকিৎসা লোৱা প্ৰমাণ পত্ৰ আদালতত দিয়া নাই। সত্য নহয় যে মই শপতত লিখা শতকৰা 60% অৱস্থা এই ঘটনাৰ কাৰণে হোৱা নাই। চিকিৎসাৰ কাৰণে মই ছুটী লৈ আছিলোঁ আৰু ছুটীটোত মই দৰমহা পাইছিলোঁ। ডিচেবিলিটি চাৰ্টিফিকেট মোৰ নাই। মই এই বছৰত 8,80,000 পাবলৈ বিচাৰিছোঁ। সত্য নহয় যে মই উঠি যোৱা গাড়ীখন দুৰ্ঘটনা হোৱা নাই।
মই উঠি যোৱা গাড়ীখন
মই উঠি যোৱা সত্য নহয় যে it was suggested.
I understood. He denied.
And my learned friend also suggested সত্য নহয় যে দুৰ্ঘটনা ট্ৰাকৰ ভুলৰ বাবে হোৱা নাই।
That was denied.
Would the advocate for the insurance company suggested that the accident was not followed for their respective vehicle, but it was denied.
Denied.
That means that it was the
Both are at fault.
responsible. Since no police case was registered,
Where is that police report? Exhibit 1,
only the accident.
page.
27. Column number 6. That is cross to date. অসমীয়াত আছে ন? Evidence to অসমীয়াত আছে।
How can this be?
That is why that's it.
This is erroneous.
Accident on the basis of GDNT number, the police.
The
report was-
claimant is smiling because it is the tussle is between the two insurance company, isn't it? You want your money, absolutely. But it is I don't think it is correct to fasten the liability only on the bus insurer, because the negligence and the fault and the involvement of the two offending vehicle is clearly evident from the evidence, and this seems to have been ignored by the tribunal.
My lord,
To that extent, I shall interfere.
there was no such issue framed by the luggage food bill.
No, that is all right, but now
this is the
everything.
negligence of both sides.
Correct. So that is why I'm saying you have nothing to lose.
Yes.
Both parties have to proportionately pay the compensation
Yes.
so awarded.
Can you hear it?
I'll hear you. I'll hear you.
Submit.
Yes.
The thing is, I have not got the evidence part.
Evidence
So it is-
part you just
yes,
read,
yes,
you
my
just
lord.
marked it.
Yes, yes. So far as cross of OP number 3, NI is that, I may be wrong, lordship, last line of the cross. মই উঠি যোৱা গাড়ীখনৰ দুখত দুৰ্ঘটনা হয়। মই উঠি যোৱা গাড়ীখনৰ দুখত দুৰ্ঘটনা হয়, cross by OP6. জনা যায় যে, not a fact নহয়, জনা যায় যে, মানে it is in knowledge. Accident মানে দুৰ্ঘটনাটো ট্ৰাকৰ ভুলত হোৱা নাছিল। ট্ৰাকৰ ভুলত হোৱা নাছিল।
I think that's a suggestion.
No, lordship, it's said
Where are you reading from?
by the cross. I have
It is.
in the last
Do
line.
you have, Ms. Chaudhary, I'm giving you the trial
Yes,
court
yes.
records.
It is not a fact. The
It's a
judge-
suggestion. Please
Lordship-
verify.
Lordship,
Please verify, Ms. Chaudhary.
Above that, lordship, may kindly see the
See, Ms. Chaudhary,
Lordship.
you verify the evidence because you see, we cannot do anything more than that. Whatever is on record is on record. If record shows two offending vehicles are involved, proportionate. If record says no, only one is involved, then that will stay. So now you please see from the cross, you satisfy yourself.
My lord, appellant did not adduce any evidence before the tribunal.
Sit. You will get your money. Sit. Mr. Talukdar, take your seat. Councils, I do not appreciate this conversation and dialogue amongst you all inside the courtroom. You address only the court. Please take your seat now. If you want, Ms. Chaudhary, you may read the entire evidence. I shall give you all the time. You read it.
yes, in the cross by OP number.
First you read again that part,
Yes,
that evidence
Yes,
part, and then you come to the cross.
Yes,
Because you see, deposition is the chief.
Yes, Lordship.
Cross is only clarification,
Yes.
right? So we have to take both together.
Yes, Lordship.
So now you read that evidence and
Yes,
then
Lordship.
read the cross.
The claimant of this present claim, I filed the claim case for the injuries sustained by me in a road traffic accident on 12/12/2008 at about 6:30 p.m. at Deusur RCC Bridge NH 37 under Japalavanda Police Station. While I was traveling from Golaghat towards Nagaon as fare paid passenger in vehicle bearing registration number so-and-so bus. On our reaching Deusur RCC Bridge NH 37 under Japalavanda Police Station, another vehicle bearing registration number so-and-so came from the same direction in a rash and negligent manner and knocked down the bus from behind with a great force. The driver of the bus suddenly applied hard brake in the middle of the road. As a result, both the vehicles damaged badly. The bus in the middle of the hard brake, then it goes
All right,
backside
Ms.
of the
Chaudhary,
road.
noted.
That both the vehicle damaged badly. The passengers of the bus also sustained injuries on their person and body. I sustained the following injuries, so-and-so. I have submitted X-ray prescription, so-and-so. And
The rest I don't think is important.
No,
Now
no,
you go to
injury
the
is not
cross.
required,
Now
Lordship.
you go to the cross.
Yes, Lordship. Page number, Lordship will find at
No,
23
you,
back page.
you have it,
says-
so I
yes,
don't
yes,
have it in
Lordship.
front of me. You
The
read.
cross by OP number 3, that is the appellant, Lordship.
Yes.
On 12/12/2008 তাৰিখে 7:30 বজাত মই 709 বাছৰ গোলাঘাটৰ পৰা নগাঁওলৈ NH 37 লৈ গৈ থাকোঁতে দশেৰা RCC ব্ৰিজৰ ওচৰ পোৱাৰ লগে লগে আৰু দলঙৰ মাজ অংশ পাওঁতে গতি হ্ৰাস কৰাৰ পিছতে পিছফালৰ ট্ৰাকে খুন্দা মাৰি ফলত মোৰ পুভৰি আঁঠুটো দুৰ্ঘটনাত হাড় ভাঙিলে। প্ৰথমতে জখলা বন্ধাত ফাৰ্ষ্ট এইড লওঁ। মই কোচবিহাৰ চিকিৎসা লোৱাৰ ডাক্তৰী দাখিল কৰা হয়। These are medical papers. সত্য চিকিৎসা লোৱা আদালতত নাই। সত্য নহয় যে মই শপত নামত
সত্য
লিখা-
নহয়।
সত্য নহয়। This is
Suggestions,
yes.
yes.
সত্য নহয় যে this is suggestion. সত্য নহয় যে মই শপত নামাত লিখা মতে শতকৰা 60% মানে ডিজেবিলিটি নহয়। মই ঘটনাৰ যিটো আছিলো সেইটো এইটো কাম কৰি আছো সেইটো কৰি আছো। চিকিৎসাৰ কাৰণে পাইছত এইটো সত্য নহয় যে that is not there. After that it is not a fact. This is not there. That relates to that line only. It is not there.
Anyway, you read.
Yes, yes.
You
আচলতে
continue
এইটো
reading.
এতিয়া
Please
কৰি
stop the
আছো।
commentaries.
Yes, yes. চিকিৎসাৰ কাৰণে মই ছুটি লৈছিলো আৰু ছুটিটো মই দৰমহা পাই আছিলো। ডিজেবিলিটি চাৰ্টিফিকেটত মোৰ সহি নাই। মই এই গোচৰত 8,80,000 লৈ পাবলৈ বিচাৰিছো। এইটো নাজানো এইটো নহয় এইটো চাৰে চাব
সত্য নহয়,
Your Lordship will see, মই উঠি যোৱা গাড়ীখনৰ দুখত দুৰ্ঘটনা হয়।
What does it say? মই সত্য
এইটো তেওঁ কৈছে সত্য নহয়।
সত্য নহয়, মই উঠিছো গাড়ীখনৰ দুখত দুৰ্ঘটনা হোৱা নাই।
আচ্ছা।
এইটো সাজেষ্টেড।
Okay, okay,
সত্য নহয় যে দুৰ্ঘটনা ট্ৰাকৰ ভুলৰ কাৰণে
okay. Okay.
জনাই যে জনাই নেকি দুৰ্ঘটনা ট্ৰাকৰ ভুলৰ কাৰণে হোৱা
All right.
নাছিল।
Noted.
That is the suggestion.
Okay.
That is the suggestion. If Lordship cross is not the exemption and seal is the main Lordship, then he has stated suddenly he stopped. Suddenly the bus stopped in the middle
And
of the
he got hurt.
Yes, yes. Suddenly stopped. That is their Lordship. The driver of the bus suddenly applied hard brake. in the middle
It's
of
all
the
right. I've read it.
That's why Lordship.
Okay.
That's why. And more above all, Lordship, no document. Just like my learned minister said, the GD is there, all things is there, materials is there. There is nothing. Accident information report. These things are not before the tribunal. Nothing. No search sheet. Nothing. The thing is that only the accident information report, and they have
What is there?
accident information report, that is exhibit 1. Lordship will
So,
see.
but that
Lordship
is,
kindly say.
that only talks about one offending vehicle.
Lordship will see that
Column
is a-
6.
Yes, column number 6.
Mr. Bhatta, what is this?
Lordship in,
Why are you interfering?
Lordship in column number 6, exhibit 1, that is accident information report. Their Lordship AS 25A5429709 bus is reflected, Lordship.
AS,
Lordship. AS 25A, that is the bus.
That is the
accident,
bus.
bus.
Correct. That's what I said.
Yes,
In that accident report, only one vehicle
Yes,
is
sir.
mentioned.
Yes, Lordship is correct.
That's the bus.
But the thing is that Lordship, while cross-examining the opposite, the appellant never challenged this accident information report. Never challenged. Why this other vehicle is not there? They have not challenged it. They have not put any questions to this on this point, Lordship. And now filing GD photocopy, which is not in the record, how it can be believable, Lordship? How it can be?
What does the
acceptable?
GD say?
GD, nothing, no record. Just. my
No,
learned
what
friend
does the
has submitted.
GD say?
GD is not in the record, Lordship.
No, but this page
Yes,
14,
yes,
what
yes,
does it
yes.
say? It says 2 vehicles.
Yes, yes. No, no. No, only GD is reflected, Lordship may kindly say.
No, what is this
Yes, yes,
GD for
no,
248?
that is in the memo of appeal. not in the
Correct. No,
record.
no, I understood. Ms. Chaudhary, I am
Yes.
following what you're saying, but I am asking you that this GD which they have annexed with the memorandum of
Yes.
appeal, that GD entry shows 2 vehicles. But these
Yes.
things were not brought before the. I'm
Yes.
understanding.
Yes,
মই বুজি
yes.
পাইছো আপুনি কি কৈছে, Ms. Chaudhary.
But,
Oh.
Lordship will see page 11, Lordship. Only one GD, that is 246 is there. On the basis of that, the case was registered.
No, I think case was on the basis of that accident report.
Yes, yes,
Correct?
yes,
Which
yes.
was exhibited as Exhibit 1.
Right, Lordship.
That is that
Uh,
column 6, which talks about only one
Yes,
vehicle.
Yes, Lordship. Because, Lordship, they have not challenged that.
So I think that is the issue now, that whether 2 vehicle is involved or 1.
Yes,
Now,
Lordship.
there are 2 set of, looks like the 2 set of evidence.
Lordship.
One is the evidence of the claimant and one is there is an accident report. Evidence in chief says 2 vehicles. Now, how the court has to see whether it
Yes.
proves or it doesn't
Yes,
prove. Accident report only talks about 1.
Yes,
But
Lordship.
merely because the accident report talks 1, though it appears that 2 vehicles otherwise is involved,
And Lordship.
whether the imposition, whether the fastening the liability of one insurance company is correct or not. That is the issue.
Yes, Lordship.
That is the
appealed,
issue.
that's
That
why
is the
it was
issue,
filed.
Mr. Bhatta.
But the thing is that, Lordship,
Now,
appellant
this court has to go by record, so we will see.
is the New India Insurance Complaint, the appellant, Lordship, they have not filed, they have not adduced any evidence stating their plea, Lordship. They have taken the plea in the written
I've
statement, no
understood that
evidence.
GD entry
That's
is not on
proof.
record.
Yes, and
I've
they have
understood.
proved the case.
I have understood.
Except that AIR, that is accident report, that was also not challenged. That was no question was put on that.
See,
And
that
no
is
evidence on
okay.
that part,
That is
Lordship.
all right. But only thing is
Without
that
any
now,
evidence-
before the tribunal fastens it upon the insurance company,
Yes, Lord.
the tribunal must be satisfied that
Yes,
out
Lord.
of the 2 offending vehicles, only 1 is
Yes,
involved.
Lordship.
If the tribunal
Yes.
satisfaction is not on the basis of the materials placed before the tribunal,
Yes.
then that satisfaction becomes erroneous.
Yes, yes.
But if that satisfaction is on the basis of the materials,
Yes, yes.
that is on the basis of the evidence,
Yes.
then this court is not going to disturb.
Yes, Lordship.
So at the end of the day, that evidence will come very important, that claimant's evidence,
Yes, Lordship.
because that is the main evidence.
It is,
That evidence nobody is disputing.
Yes. that is
Everybody is accepting that
Lordship,
evidence,
Lordship.
right? So let me have a look at the evidence
Yes,
once
Lord.
again, and whatever comes,
That-
accordingly, the judgment will follow.
Yes, that is,
Alright.
learned member has taken care of all these things and came.
Yes,
to-
that's what exactly the
came
appellate
to,
court
yes.
will have to now
Yes, yes.
examine.
Conclusion, yes,
That's the question.
Lordship,
Yes. So I am not closing it today.
Lordship.
Arguments are concluded, Mari Dixon. I'll fix it on Thursday. Most likely I'll dictate the judgment on Thursday in court.
Lordship.
Yes, any authorities you all want to give it. You can give it today because I
Yes,
am
that's it.
fixing it anytime today. You can give it to the court master, Ms. Chaudhary. Item number just indicate, huh?
Yes, yes, yes.
It told you because I am only keeping it on Thursday with the understanding I'm going to dictate the judgment in the court. So
Lordship.
no further arguments.
My
Yes.
full submission is that accident information report is the only information, Lordship. Only information, and this information was issued on the basis of CTNG. But the police officer issued this information without considering the CTNG. But the CTNG number was there. That is why we placed get CTNG, Lordship. That as far as CTNG was
In other words, are you trying to say that the tribunal ought to have called for these
Yes.
documents?
yes,
Are you trying to say that?
Yes, please. Because
I-
no eyewitness was examined except the claimant. Was the claimant also
And-
stated that the vehicle was responsible.
And Lordship, appellant was not helping the court. They have not.
Ms. Chaudhary,
Evidence.
Ms. Chaudhary, I have patiently heard you.
Lordship.
Now please allow Mr. Bhatta to
Lordship.
give the reply. Yes, what else, Mr. Bhatta?
that's why I said that the GD number 248. On the basis of the 248.
The report was given.
Report was, as per the GD number 248, how the accident took place, it was properly mentioned. As per the GD 248, and their responsibility was fastened on the truck, not the bus.
Lordship, this is wrong, Lordship, not as per GT 248, as per 246.
Miss Chaudhary, please do not disturb
sorry,
when
Lordship, I'm
because
sorry.
this is not a very healthy way of practicing,
I'm
Miss Chaudhary.
pointing out,
Because
pointing
you see, you had your chance. I heard you properly. Now the appellant has a right to reply. He is
Lordship,
replying. Let him finish.
Pointing out
Why are you interpreting? When Mr. Bhatta was interfering you, I had stopped him.
Lordship.
So it goes, same goes to you, Ms. Chaudhary, because you see, when both councils submit, the court doesn't understand anything.
Yes, I have both GD entry, Lordship. 246,
Why two GAD entries?
initial information regarding accident,
Was 246
246.
and the
Then
subsequent was 248.
248 investigation.
But these entries were not exhibited in the trial court.
Yes, yes.
And you have also not questioned anything about these. You were there during the trial. Your counsel was there. The counsel was there. The insurance company was
Said that the accident took place due to
two vehicles.
Two vehicles. And as for the evidence on claimant, Lordship, it was the accident took
No,
place
but the accident report was exhibited. It was exhibited through the claimant. So at that time, you did not object because the accident report clearly mentions only one vehicle, Mr. Bhatta.
But they had made both the vehicle as a party in this proceeding. Lordship.
That's okay. But accident report, which is based on all the investigation, that mentions only one vehicle. And you have never objected. You have never challenged that. Have you challenged?
No, sir.
That you have not.
No issues.
It is reflected, Lordship.
On that, if you have something, you find some authority or you find some authority, Thursday on that point you give. Because you see, Mr. Bhatta, that accident report is not, you have never objected or challenged, where it only involves one vehicle, which is absolutely against what you are saying, isn't it? Or what the claimant in his chief initially said. So now nobody has raised any objection. The tribunal accepted that and fastened the entire liability on you.
But they have also not such a state.
They don't need to. They are happy that the accident report doesn't talk about their involvement. The claimant is not concerned whether A will give or B will give. The claimant only wants the compensation, rightly so. He has been hurt in an accident case. So I'm just reflecting the mind of the court so that you can do some homework on that part. Hard in part, release Thursday, so and so.
What applies, Lordship?
A trial court reports. Mr. Chutia, I think the time frame is required because the pension paper, some objection was raised by the accountant general and it was supposed to be resubmitted. Now, what has happened to that? If it is not resubmitted, how much time is required? Because this pension is pending.
We have submitted resubmitted it, but the point now is raised by the my lord AG regarding regularization of the workshop employee. He was appointed, my lord, after 1493. In 1994, my lord, he was appointed, and he was brought back to my lord to the regular cadre in 2011. For those 94 to 2011, his service is required to be regularized by the government, my lord, chief engineer. So we wrote to the chief engineer for regulation of that particular period. And if that particular period, whether he can be regularized in that period, my lord, this
the court may also decide it, my lord, but he was appointed after 1493. In the Upendra's case, my lord, those who are appointed after 1493, they can only get the, my lord, regular
So
state
that
of
is
pay.
why you are not being able to resubmit.
No, we have already resubmitted it, but they did not.
No, no,
receive it. And then
see-
after receipt of that letter, my lord, my instruction is that we went personally to the office of the accountant general.
After 15/10/25.
My lord, on 1/7/2025, the officials went to the, my lord, office of the accountant general, but it was refused to accept the, my lord, pension paper on those grounds, my lord, and it was again returned, my lord.
Then you put an affidavit.
My lord,
You have not filed any affidavit.
my lord, my lord.
So you
Just, my
place
lord,
this
today I
on-
have received the instruction, my lord.
Let this come on record. Huh?
All right.
Heard Mr. S.K. Das, learned counsel for the petitioner. Also heard Mr. J.S. Chutia, learned standing counsel, AAC, and Mr. R.K. Talukdar, learned standing counsel, AG. Huh? Mr. So-and-so, learned standing counsel, KAC, submits that instructions as regards the status of the pension papers of the petitioner has been received by his office and accordingly prays a short accommodation to place the same by way of an affidavit. Prayer is allowed, a relist after 2 weeks on a date to be fixed by the registry. You see, since you are disputing that position, so your what I meant is that you file a detailed affidavit about everything, because it appears then ultimately an adjudication would be required. So I don't want to further delay the matter on the ground of pleadings and all. So whatever you want to file, you file it. If a detailed,
2023, 12 years his regular service is
so
there.
whatever be it,
My
you
lord.
put everything and so that a fair opportunity is the petitioner gets a fair opportunity to rebut.
My lord.
So
My
you know, detailed denials, whatever.
Yes.
Huh?
My lord.
Item number 13.
Item number?
There are 5 crucial aspects, I
Hmm?
have submitted the.
Yes, yes. Your main thing is that acceptance doesn't mean accepting. It means only receiving. Probably your argument is that is receiving. Correct?
Yes, and the recommendations incorporated in the inquiry report is not binding, and
The
not binding, those recommendations incorporated in the inquiry report. That may be furnished by the inquiry officer, but that is not binding. And our most important aspect, if there is no evidence of perverse, then, the under Article 226, the court has the jurisdiction to go into the entire aspects of the matter. But if there is some evidence, and if it is not perverse, then in the midst of the inquiry proceeding, under Article 226, is not maintainable. 2 judgments have been furnished by my learned friend of coordinate bench, one by your lordship, but those are regarding post-appellate, post-penalty stage, But here, it is pre-penalty, pre-appellate stage. Penalty has not been imposed as yet.
yes, but
So
before
it's
that
under
is the
process.
second show cause notice stage. Correct? Mr. Sharma, this is the second show cause notice stage.
Second support.
So the issue that involved here is, well, of course, he's argued few more aspects, but one of the question that this court is looking into is that whether the disciplinary authorities have acted with an open mind or not. In as much as it is apparent from the record that at the time of issuance of the second show cause notice, the authorities have already accepted the finding of the inquiry officer because of the word used is accepted. I will deal with the arguments and see what ultimately the outcome comes. But I am saying this is the one of the issue, right, Mr. Phukat? I've understood that part correctly, na, Mr. Sharma? That is the thing.
Yes, ma'am.
So now, because you see, the justice is not only to be done, justice is to be seen to be done. This is what is the concept of justice, right? Similar is the situation when the matter is before the disciplinary authorities. Now, if the disciplinary authority accepts the finding of the inquiry report and puts a notice to the delinquent, he accepted. Now you say what you want to say.
There,
Can it be said,
my lord,
can it be said that the disciplinary authority has acted in an open mind? Because you see, he may have, but can it be said that justice is seen to be done in that situation?
my lord,
That is also another question, because entire proceeding has to be fair, transparent,
my lord. My lord,
correct?
my lord,
So I am on that.
my lord.
You, of course, you have relied dictionary meanings to bring out what acceptance means, that doesn't mean. That's another aspect. Of course, now I'm hearing it, so we'll get, I shall go into all those aspects. But I am only saying that is the,
Prima facie, that
Yes.
acceptance word.
yes.
But in the factual scenario, the chronology of events, after that acceptance, the matter went to the, my lord, executive council.
That will obviously,
My lord.
see, Mr. Fukan,
My lord,
those are procedural, those will follow.
my lord. And,
So, but it cannot negate
my lord,
that prior to putting him under notice, it was accepted. These are procedural. So what it means is that they didn't proceed from that stage with an open mind. Because at that particular point, while issuing the second show cause notice,
my lord,
acceptance was already taken. So they had already decided in the mind
my lord.
that we are going to accept. But of course, they are aware that if we don't put the second show cause notice,
So his stand is that it would be a empty form. My lord.
that is his stand.
The-
Because it is only to show that there is procedural compliance, the subsequent consequences are following.
my lord,
Only because of that word accepted.
but
That changed the entire game.
my lord,
You see,
that will seal the fate of the
correct.
delinquent.
That is why I started by saying justice is not.
Seems to be done. My lord, I'm relying on those judgments. From those judgments, it is clear, my lord, that inquiry report, there are three aspects. It would be accepted in full by the disciplinary
No,
authority.
that is,
One
there is,
aspect.
you see, Mr.
Second,
Fukan,
partly accepted.
there is no quarrel to that
So,
proposition.
it will have
But
to
you see,
convey
you
the-
see, you have to address the issue vis-a-vis the principles also. Because why first of all, why is a show cause notice given? Second show cause notice given to the delinquent? Why?
As per that Ramzan Khan and
No, for what reason?
for his response.
For his
Before
response?
his response, my lord, he will have to convey that it is fully accepted, partly accepted, rejected. These three aspects are there as per Supreme Court's judgment.
Which one? Show.
So, my lord,
You have given that in your.
yes, my lord, written law.
Take your seat, Mr. Sharma.
My lord, 99 7 SCC, that
99.
7 SCC 73.
You have not paginated the compilations.
Sorry, my lord,
Which one? 90?
1999 7 SCC 739.
And so many decisions are there. What's the party name?
Yoginath D. Bagre
Okay,
versus
I've got
State
it.
of Maharashtra.
Yes. Paragraphs
Paragraph 31 and 51.
51 and 51. Yes, let's see.
Uh, May I read, Miller? In view of the above, a delinquent employee has the right of hearing not only during the inquiry proceedings conducted by the inquiry officer into the charges leveled against him, but also at the stage at which those findings are considered by the disciplinary authority and the later, namely the disciplinary authority forms a tentative opinion. It is important, Miller. The disciplinary authority forms a tentative opinion that it does not agree with the findings recorded by the inquiry officer. If the findings recorded by the inquiry officer are in favor of the delinquent and it has been held that the charges are not proved, it is all the more necessary to give an opportunity of hearing to the delinquent employee before reversing those findings. The formation of opinion should be tentative. It is important, my lord. The formation of opinion should be tentative and not final. It is at this stage that the delinquent employee should be given an opportunity of hearing after he is informed of the reasons on the basis of which the disciplinary authority has proposed to disagree with the findings of the inquiry officer. This is in consonance with the requirement of Article 311(2) of the Constitution, as it provides that a person shall not be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. So long as a final decision is not taken in the matter, the inquiry shall be deemed to be pending. Mere submission of findings to the disciplinary authority does not bring about the closure of the inquiry proceedings. The inquiry proceedings would come to an end only when the findings have been considered by the disciplinary authority and the charges are either held to be not proved or found to be proved, and in that event, punishment is inflicted upon the delinquent. That being so,
These are cases, I think, in the context of some rules where a disagreement note has to be given.
Miller,
In your case, a disagreement note was given.
Miller,
Is the rule says that, I'm quite sure because there are certain rules which says that in the event the disciplinary authority is not agreeing with the findings of the inquiry officer, then in the show cause notice, they will indicate the disagreements, why they are not, and then give it to the, so what is the facts of the case?
if the delinquent is
Here, what has happened?
Milord, then Milord,
What did the inquiry officer do in this case? Yes, he is in favor of the delinquent officer.
Milord,
You see, these are those kind of cases.
Milord,
Obviously,
that-
in that context, the disciplinary authority has to give the reasons why they are not agreeing, the reasons for disagreeing with the findings of the inquiring authority. The rules are saying,
then this
you see,
51,
read para 29.
Yeah.
You see, that is the law.
Milord,
Law has to apply in the context.
Context of
Decisions
the-
of the apex code is contextual.
Milord,
We cannot ignore the context.
Milord.
Yes, para 29.
We have already extracted Rule 9(2) of the Maharashtra Civil Services so-and-so Rules 79, which enables the disciplinary authority to disagree with the findings of the inquiry authority on any article of charge. The only requirement is that it shall record its reasoning for such disagreement. The rule does not specifically provide that before recording its own findings, the disciplinary authority will give an opportunity of hearing to a delinquent officer. But the requirement of hearing in consonance with the principles of natural justice, even at that stage, has to be read into Rule 9(2), and it has to be held that before the disciplinary authority finally disagrees with the findings of the inquiry authority, it would give an opportunity of hearing to the delinquent officer so that he may have the opportunity to indicate that the findings recorded by the inquiring authority do not suffer from any error and that there was no occasion to take a different view.
So are you following? Why?
Milord,
Because the report is in his favor.
Milord,
These are that situations.
Milord,
Obviously,
Milord,
the inquiry officer's report is in his favor.
Milord.
Now you are disagreeing. So why are you disagreeing? Before you take that final call, you have to put him on a notice that these are the reasons why you cannot accept the inquiry officer's report, which is in his favor. Obviously, there you have to indicate. This is not that case that you are going to rely on this decision and show, okay, no. At the time you are giving a show cause notice of imposing penalty, you will accept and then do it. That is a different. All those decisions are there of the apex code, ECIL and all that.
Milord,
Predetermined mind cannot be. It is not unacceptable.
Milord. So, Milord, after acceptance, this tentative provisional acceptance, Milord, he has been,
Mr. Fukan, have you understood?
Milord.
This decision doesn't apply.
Milord,
The line of argument that you are developing from these decisions will not apply in the facts of your case. You've understood that, right?
Milord.
Yes.
Then, Milord, this paragraph 51 of that judgment, my lord.
It will be of no consequence. The fact this is on a different facts. Mr. Fukan, I am here to, you can carry on arguing, but you see, you place me a decision which is in your, which is of consequence to you. This is a different context.
My lord. And particularly, my lord, that post appellate and penalty stage, my lord, as per this judgment, my lord, the DP, my lord, concludes after imposition of
That's
penalty
all that is immaterial.
in the midst of the inquiry, my lord, inquiry proceeding, my lord, under Article 226, my lord. Since, my lord, there
If this court notice there has been an infraction of natural justice, we will set it, we will turn the clock and put it back.
my lord, I agree with you, also, my lord, that no evidence and perverse.
That is different. That I'm with you. Mr. Fukan, I'm with you as far as that part is concerned.
My lord.
You're absolutely right. The 226 court is not going to go into the factual aspect and sit as an appellate authority over the findings recorded by the inquiry officer.
My lord.
That this court will not do.
And that opportunity of cross-examination has been, my lord, given to the delinquent on 20.
You were showing something. I had forgotten. From where were you showing that?
Page 89 of the writ petition, my lord.
Page?
89, the inquiry report, my lord. Page 89.
Yes.
89 in the middle portion, my lord.
Yes.
On 27/01/2025. That is very important. my lord.
Yes.
On 27/01/2025 in the middle portion, the charged officer was again given the opportunity to cross-examine the prosecuting witness. This time, he cross-examined the PW as follows. So on 27th, he was given the opportunity and he examined that R.A. Chaudhary, but subsequently, PW6, he declined. Page 91. Fifth, sixth line, cross-examination, page 91, my lord.
Yes.
The charged officer
Declined.
declined to cross-examine the PW6. This is on 27th, my lord.
Yes.
Then this Deputy Registrar Prashanta Burman, he is the
Yes.
presenting officer.
Yes.
He has given the, my lord, statement. Then down below, statement of the charged officer, the concluding statement.
Yes.
Same day, my lord. He given to the
So all this
inquiry
happened on the
officer.
27th.
27th. Now he, after 3 days, my lord, he suddenly become wise, my lord, and submitted an email.
When was that? Page?
My lord, 78 and 79. Kindly note the date, my lord.
31.
31.
And that was
at 4:52
27/1,
PM
huh?
in the evening.
27/1/25.
My lord.
After 3 days.
The last 3 lines of the second para.
Yes.
Under reference above, however, the Honorable Court in paragraph 20 had granted your good self the liberty to consider my application for cross-examination of the prosecuting witnesses. On 27th at 10:30, my lord, that judgment was pronounced, and at 2:30, my lord, everyone is in the know, my lord, about that judgment, my lord. And in spite of that, my lord, the delinquent refused to cross-examine the witnesses, though he has been given the opportunity as per the direction of this Honorable Court on 27th at 10:30. So after 3 days,
27/1/2025, in the court proceeding, the delinquent was given direction to further cross-examine.
Yes. Liberty.
And on that 27/125, before the inquiry proceeding, he had declined. It can be so that the council has not communicated to him on that moment. We don't know what has happened. But then since on 31/25, the inquiry officer was intimated because the inquiry did not finish on 31. Ultimately, what is the date of the inquiry report?
13 February 2025.
Huh?
13 February 2025.
So then, see, that's why the words I use is justice not to be done, to be seen. So another opportunity could have been given because the High Court's order is there to avoid these issues. It is only complicating, na, Mr. Fugan?
You know, that
13 to 25,
13 February 2025.
the inquiry report.
Inquiry report, and EC took the decision of acceptance on 13/5/2025 after 3 months.
Okay, anything else?
No, Milord. And regarding that cross-examination, Milord, that may be, Milord, allowed, Milord, still, Milord. If
No, you
this-
see, there could be, I am yet to hear the reply,
Milord,
but at this moment, I feel it should go back to the cross-examination stage
Milord,
where a fresh opportunity for cross-examination and then it will follow. And because you see, ultimately too, that acceptance has no meaning because that notice, where is that page? That word accepted appeared in which page?
My lord, that starts at page 80, my lord.
8?
80, my lord. 80. And
Has been accepted by the council. So this I am going to interfere for sure. This cannot stand. It is going against the, you know, otherwise I would have sent it back to this date. But now that's the fact that there is an order of this court whereby they were allowed to cross-examine, and this was brought to the notice of the inquiry officer by that email. Thereafter to not give, it doesn't look good.
Milord, but
You are right in
on
saying,
that day itself,
you're right, mister, but you know you know it. You all are the most aware of the practical things that goes on in the court.
Milord,
You tell me one thing, is it sometime does the client immediately always comes to know on the date the orders are passed? Sometimes the orders are given on the second day also
Milord, that-
after being dictated on the first day because of so many reasons, because of infrastructure reasons.
Milord,
The stenographers takes down the orders. It has to come for editing, re-editing.
Milord.
It may take a day. How do we know?
You know, it was the issue. was regarding-
Coincidentally, on the same date, the proceeding was going on. He declined. But the fact that there is a judicial order, where is that order, Mr. Sharma?
my lord, the order is at page 68, my lord. The operative portion is at 77.
77.
60?
It starts at 68. The operative portion is at 77.
The above being said, in the event the petitioner has not been able to cross-examine the three witnesses on 16/1, the IO should consider giving an opportunity to the present petitioner to the cross-examining the witness. Now 60, but then Mr. Sharma, you see 16/125 you have not.
Yes.
But on 27 you were asked.
Yes.
You did cross-examine one or two. Then you declined.
My lord-
Then what remains?
My lord, what happened is,
One second, just Sharma, have you finished or you want to say something else?
uh,
Let me just finish one by one.
Milord,
You be ready with that answer.
Yes, my lord.
Sit down.
Milord,
Yes.
my affidavit in opposition, Milord, regarding that acceptance, Milord,
Hmm.
the chronology, Milord. Kindly turn to page 127, Milord.
1.
27. The communication regarding acceptance was of 13/5/2025. Then this agenda of EC meeting subsequent to that, later.
That's
that
right.
communication.
See, Mr. Fukan, I don't think this.
Serial number 8.
I can understand, but you can only go by records. These are all consequential. They will not. They will not do good to the damage that has been caused by issuing him that show cause notice where you have already indicated the council has accepted. It will not,
At least, Milord, there is one aspect, Milord, but this serial number 8, it will, Milord, clarify the mind of the
that's
disciplinary
okay, whatever the mind is,
consideration
whatever the
of
mind is, not to be praised, consideration. I have understood. I understood what you're trying to say, but that word accepted has created a lot of problem.
apparently, Milord, that
And
acceptance
we
means
are on that
acceptance,
apparent only.
Milord. Milord. So, Milord, this is acceptance part and that, Milord, cross-examination part.
Cross-examination, I think you may be right. They declined subsequent to 16.
Milord. On 16 decline and.
And then
the
an
issue
opportunity was
regarding-
again given.
Milord, regarding engagement of, Milord, legal officer, Milord, by a lawyer, by a
Hmm.
lawyer. That was refused and, Milord, all are in the know, Milord, on that 27th, Milord. That is why that inquiry
So that,
proceeded.
with that
Milord.
we cannot say that they
Right
knew,
now,
because
Milord.
I've indicated
Milord.
that we don't know.
Milord.
But then the order of the court is also such that it is not a positive direction.
Milord,
It is coming with a rider
Milord.
that if on 16 they were not allowed,
Then
then subsequently
get the
to
leave.
give them. But but now going by the facts, pursuant to 16, they were given the opportunity.
Milord.
That has come from the report.
Milord.
And at that time, they declined.
Milord.
They did cross-examine one,
Yeah.
isn't it? One or two, I think they cross-examined.
One cross-examine, 2, 3, 4 decline, Milord. Then 5 and 6, Milord.
Anyway, I'll hear you
Yes.
patiently. Don't worry,
No,
Mr. Sharma.
I could only cross-examine one.
One, that's right. Only one.
And 5, Milord. Proceed.
He'll verify. Just see 5 also,
Five.
huh?
Milord, is
In fact, Ziaur Pasa and RH Chaudhary.
So they are 5, 1 and 5.
One,
1 and 5.
2 and 5 rather. Ziaur Pasa.
PW5 Rafiqul Hasan RH.
তেওঁ কৰিছো আমি pass
5 or 2.
Yes.
2
And this was done on 27.
27. On 16th, PW1 was cross-examined.
Okay.
Ziaur Pasa.
PW5
Yes.
on
All right.
27th.
Anything more?
But he on 16th, he declined, Milord.
Understood,
16th,
understood.
that RS Chaudhary. But on 27th,
He did.
while he was given that opportunity,
He did.
He did.
He did.
But declined to cross-examine.
That I understood, Mr. Fukar. I've understood.
That's my suggestion.
I found it difficult at that moment to accept, thinking there is an order of this court. But upon seeing the order of the court, it comes with a rider.
Yeah.
That appears to be satisfied. Okay?
Yeah.
Yes, Mr. Sharma.
My
All yours now.
Yes, my lord. My lord, I'll request your lordship's attention to page. To the inquiry report, my lord, your lordship will kindly come to page 90, my lord.
Page
Page 90.
90.
Yes, my lord. PW6. A statement
Yes.
Statement of Mr. Badrul Islam, APS, Deputy SP, Directorate of Vigilance and Anti-Corruption, Assam, Guwahati, recorded in connection with departmental proceeding initiated against Professor Khatoniar, who is the petitioner, my lord. Now, my lord will kindly come to page 91, my lord.
Yes.
The charged officer declined to cross-examine the petitioner, the prosecution witness number 6, which is Mr. Badrul Islam. Now, there's a reason as to why that happened, my lord. The lordship will kindly come to page 34, which is the memorandum of charges.
Yes.
Then, my lord, will kindly come to page 40, which is the annexure 4, which is the list of witnesses.
1 second. 34, you wanted to show what?
34
Memorandum
is
of
the
charges.
memorandum of charges.
Yes,
my lord.
then?
Page 40, which is the connected annexure to that memorandum of charges.
Yes.
Your lordship sees that.
Yes.
My lord, in the list of witnesses, Badrul Islam was never mentioned, my lord. He was introduced on that day itself. The petitioner did not even expect him to be there. The only expectation that the petitioner had on that day was in regard to Arich Chaudhary. Arich Chaudhary, I cross-examined, my lord. Badrul Islam's name nowhere features in this list of witnesses, my lord. He was introduced at that moment itself on 27/1/2025. He's the APS Deputy SP of the Vigilance Commission. He was never added as a list of witness in the memorandum of charges.
Yes,
And this statement, my lord, finds substance in my submission at page 17 also. Page 17, my lord.
of your,
The petition, my lord, the very petition. The writ petition, my lord, which states, page 17, I have prepared a table, my lord.
yes,
Number 7, Badrul Islam, 27/1.
newly added
Is
witness.
a newly added witness. The person whom I could cross-examine on 27/1/2025 was RH Chaudhary, which I duly did because his name, I expected him to be there. Then, my lord, the other individual whose cross-examination I conducted on 16/1/2025, Ziaul Pasa, I had to do it, my lord, in spite of the fact that my petition before this honorable court was pending at that point in time, my lord. I denied cross-examination of number 3, serial number 3, serial number 4, because my petition, my lord, before this honorable court, praying for a defense assistant, was still pending. And when the the judgment of this honorable court was rendered, my lord, it was an oral order at that point in time without the copy being made. We had intimated it to the client and asking him into the needful that the case had failed before this honorable court. Now I request you to kindly go and cross-examine the witnesses, pursuant to which on 27/1/2025 he did that. The only person to whom he did not cross-examine, my lord, is a person who was introduced.
Not in the list.
Was not in the list, my lord. And Professor Birinsi Kumar Das, my lord, the date is very important, my lord. On 6/1/2025.
No, on 27th, you did RH Chaudhary.
Yes, my lord, because his name initially featured in the list.
And you did another person.
No, my lord.
Only RH Chaudhary.
Only RH Chaudhary, my lord. In fact, number 3 and number 4, those requests I had made pursuant to my email dated 31, pursuant to the order of the court.
So that you had denied initially
I was
because
denied
your
initially
DA
Yes.
was not permitted.
It was not permitted and the matter was pending before this honorable court, my lord.
So, but on 27 again that was denied.
No, my lord, that was denied.
27
Yes, my lord. Because
again.
yes, my lord. That is
Anjad Brahma.
Yes, my lord. That, my lord, will find at page 78. Page 78. I had laid bare, my lord, the situation, my lord. I have in fact quoted the order also. Page 30 is an email I sent to the inquiry officer.
Yes.
That I, Professor Guru Prasad Khatonia, academic registrar under suspension, Guwahati University, prefer this instant application for your good self's consideration in allowing me to cross-examine all the prosecution witnesses as mentioned in the letter summoned under reference. In this regard, I beg to state that I could cross-examine only 2 prosecution witnesses. While I could not do the same for the other prosecution witnesses due to non-consideration of my defense assistant being a legal practitioner, the issue being sub judice in WPC number so-and-so before the Honorable Guwahati High Court was finally disposed of by judgment in order dated 27/1/2025 under reference above. However, the Honorable Court in paragraph 20 had granted your good self the liberty to consider my application for cross-examination of the prosecution witnesses. As such, I fervently pray before your good self that I may be allowed the opportunity to conduct the same. There was no response to that letter, my lord. And in fact, my lord, on 6/1/2025, where the table states, my lord, that I had not cross-examined Professor Birinsi Das, there's a reason as to why I could not do that. Because on 6/1/2025, I had sought time initially, my lord. Your lordship, the details may be relevant, my lord. 6/1/2025 is the at 62, 62, my lord.
These you have you stated all this in your
Yes, ma'am.
company?
Yes, ma'am.
Huh?
Yes, ma'am. Yes, ma'am.
In this one?
Yes, ma'am.
In your written
Yes, ma'am.
arguments? All these are there?
In fact, in the heading on the bias, my lord,
Sorry?
the heading on the bias, my
Bi-
lord, yes. Now, there's a reason, my lord, as to why I
Which
put
page 62?
page 62, my lord.
Yes.
With reference to the subject cited above, I so and so beg to state that the instant communication was served upon my email address being so and so at guwahati.ac.in, which I have not used as it is in Guwahati University's domain. All my communications were done for the last couple of years using only my personal email. I've given grounds, my lord, as to why I did not receive the letter initially that was sent by the university to me. This letter, my lord, was preferred by me on 6/1/2025. This was the same day when the authorities proceeded on the disciplinary proceeding, but your lordship will see the response at page 64. At page 64. This is by the presenting officer. I had sought initially 14 days time. The presenting officer says that I cannot give you 14 days time. We had been given 10 days time. So and so, considering the above, you're requested to appear before the inquiry officer on 16/1/2025. But the presenting officer failed to mention the fact that one of the key prosecution witnesses that was already examined, my lord. So I'd missed the bus on that day, my lord, where I had taken time and I was given time with the belief that time was been granted and the entire proceeding would start after a particular day. The authorities unilaterally decided to start the proceeding without even informing me the fact, which I got to know on 16/1, that Professor Birinsi Kumar Das would not be coming today. Why? Because he was examined on 6/1. This is the bias which had commenced, my lord, at the entirety of the proceedings, my lord. In fact, the entire aspect of me allegedly having taken bribe, there is a big alleged still there. The university had proceeded to take it as one of a proven fact. In fact, I was in Bhattadev University in Patsala, my lord, when the entire incident happened. There I was suspended. Right or wrong, I was suspended by a university under whom I was not a regular employee. I was on lien. Then I came back. The moment I joined, I was put under suspension. Fair enough. There is no dispute to that. But the fact remains, my lord, that I was not given my chances to completely exhaust all the remedies. The recommendation of the inquiry officer follows a recommending punishment to the authority, to the petitioner, my lord, which is beyond the mandate of Rule 9(7), which has been accepted by the disciplinary authority. And then the chance was given to me to prefer my reply. That's where I've come, my lord. And there was a case pending before the Honorable Court. We had intimated the order, albeit orally, my lord. The petitioner reached out. Badrul Islam was included on that day, man. I did not even know that he would be there. I assumed that I had finished my cross-examination for the day. Then I understand that there's one more individual who would be deposing against me.
Where have you said that in terms of that objection that he was not given earlier?
No, my lord, that happened. That transpired on 27th. That transpired on 27th. In fact, my letter on 30th, which I've written, my lord, page
62.
62, my lord. Not 62,
No,
my lord. I apologize, my lord. Page 78.
Correct.
Page 78.
Page
78.
78. Sorry.
So these are my grounds, my lord. That the entire process has been vitiated by an element of bias.
No, in 78, where have you talked about this newly added? Have you said? in
No, my
78?
lord. No, that I haven't.
That you have not said.
That I haven't said, my lord, because this was a letter which was initially, my lord, preferred by the petitioner. But the fact remains, my lord.
In against your paragraph about that newly added,
My lord.
what is the stand of the respondent in the affidavit?
My lord. My lord, my submission is at page 38, paragraph 38, and
I think 13.7 and 36, 37 is the chart.
yes.
Why you said the inquiry officer and the university have tinkered with the list of witness thrice?
My lord, the initial list did not have that name, my lord.
That I understood. Why thrice?
Yes, my lord.
What is the second time?
Yes. Now, my lord will kindly come to page 59, my lord, page 59. Annexure N. Here, my lord, your lordship will see Rafiqul Hasan Chaudhary is the new incumbent in this list. Singharam Mili was there, Ziaul Pasa, Anjad Brahma, Birinsi Kumar Das, academic register. This is the second
No,
list.
no, this is which list? This is the second list.
This is second list, which was provided to me on the 1st of January 2025.
So prior to 27th. So
Prior to
here,
27.
here,
But Badrul Islam does not find a mention even here, my lord.
oh, that's why Birinchi is there.
Yes, my lord. So that's a third list, which I'm assuming to be a third list.
That's why you said.
Yes,
so. Yes.
And my lord, regarding the submission of list, the submission was made in paragraph 38. Your lordship may kindly come to page 5 of the affidavit in opposition, my lord. Page, it starts at 100, 100, 101, 102, 103, 104, my lord. 100, 104, which is the affidavit which has been filed by the state, my lord, by the
Yes.
university.
Yes.
With regard to the statements made in paragraph number 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, and 42 of the aforesaid writ petition, while putting the petitioner to the strict proof thereof, this deponent humbly begs to state that the inquiry report with the findings dated 13/2/2025 has been furnished to the Guwahati University Authority by the inquiry officer concerned, and thereafter by a letter dated 13/5/2025 as issued by the respondent registrar of the
They're
university.
silent.
They're silent on that aspect, my lord.
This is only accepted about
Yes, ma'am.
the.
Yes, ma'am. Completely silent.
All right.
These are my submissions, my lord.
Just sum it up once, the moot submissions.
The mood submission, my lord, is that I am praying for setting aside of the entire disciplinary proceeding, my lord. The reason being that the inquiry officer, who's meant to be an impartial adjudicator of the entire matter, has acted with bias. The fact of the matter remains that the prosecution witnesses arrayed in the disciplinary proceeding, firstly, has been changed, not thrice, might be twice, my lord, because there have been two separate lists. And in fact, on 27/1/2025, there was a witness which was added at the last moment. The prosecution witnesses come and come from the same department in the Assam Police, in which the inquiry officer, with utmost humility, I submit, my lord, was a seasoned officer of the Assam Police, and the inquiry officer had already concluded my guilt, my lord, prior to commencing on the inquiry proceeding. I was not given a chance to cross-examine all of the prosecution witnesses for reasons being that the matter was pending primarily before the Honorable Court, as and when the mandate and and the order of the Honorable High Court was conveyed. Even then, the university did not deem it pertinent to even reply to my representation. The only prosecution witnesses that I could cross-examine were on 27th, and one on 16/1 was the Ziaul Pasa, the complainant. The inquiry officer had exceeded his mandate under Rule 9(7) of the Assam Services and Disciplinary Rules.
Why? What is this rule?
Rule 9(7), my lord. 9(7) reads of the Assam Services and Disciplinary Rules, my lord. It states that at the conclusion of the inquiry, the inquiring authority shall prepare a report of the inquiry recording its findings on each of the charges together with reasons therefore. In my case, the inquiry officer had gone a step ahead and recommended, my lord, my termination from service, my dismissal from service, which he ought not have done. He was an adjudicator. And he was an adjudicator, my lord. and his prime responsibility was to record findings on the charges which were brought against me and to present it in an unbiased, impartial manner before the authority who's supposed to take that decision. He had recommended my termination, my dismissal, which the university authority had already accepted, and thereby gave me the second show cause, rendering the entire process a mere formality. My lord.
All right.
The entire proceeding had proceeded on the bias against me. My lord. That's my submission.
Okay. Right. Heard Mr. M. Sharma, learned counsel appearing for the petitioner. Also heard Mr. PJ Pukan, learned counsel appearing for the. Are you a standing counsel?
Yes.
Learned standing counsel, Guwahati University. Stop. By way of this petition under Article 226 of the Constitution of India, the petitioner is assailing the departmental proceeding
Yes, madam.
initiated against the petitioner pursuant to the memorandum of charges dated 23/10/2024, as well as all subsequent and consequential actions thereto, and is further seeking setting aside of the impugned resolution of the Executive Council of the respondent university, where under the whereby the inquiry report submitted by the inquiry officer was accepted. Date to Diluna? Resolution to impugned resolution dated this one? Huh? 21/3/2025. Yeah? 21/3/25.
Yes, my lord. The date of the resolution of the case.
The brief facts of the case is that the writ petitioner during his service tenure at Bhattadev University on lien from Guwahati University within bracket as registrar on probation was arrested on 6/8/2022 allegedly in connection with alleged acceptance of bribe money of rupees 50,000 in front of a pre-trap team of Assam Police in ACB PS case number 24/2022 under Section 7A of the PC Act 1988 as amended. The petitioner, after being released from Bhattadev University with effect from 1/2/2023, joined his parent Guwahati University on 26/7/2024. However, on the very same day, he was placed under suspension. Thereafter, departmental proceedings has been initiated by the respondent university against the writ petitioner by issuing memorandum of charges on 23/10/2024. Stop. After receipt of written statement of defense on 4/11/2024, an inquiry officer was appointed to inquire into the charges leveled against the writ petitioner. During the pendency of the said disciplinary proceeding, the writ petitioner moved WPC 351 and filed a writ petition before this court bearing WPC WPC 351/2025, seeking assistance of defense and seeking a legal practitioner as his defense assistant before the disciplinary proceeding. Stop. In the said writ proceeding, this court, by judgment and order dated 27/1/2025, directed that, within bracket, in the event the petitioner has not been able to cross-examine the three witnesses on 16/1/2025, the IO should consider giving an opportunity to the petitioner to cross-examine the witness in the departmental proceedings. It is the specific case of the petitioner that despite the aforesaid direction of this court, the petitioner was not granted with the opportunity to cross-examine the defense witnesses. Stop. No, sorry, not defense. Charged with, there'll be what witness?
PWs,
PW.
prosecution witness.
Prosecution witness. Stop. It is the further case of the writ petitioner that the inquiry officer in a very, it is the further case of the petitioner that the inquiry officer in a in a biased manner completed the proceeding in violation of the rules applicable and have recommended termination of the petitioner, which appears to have been, which was accepted by the disciplinary authorities pre-issuance of the second show cause notice, before issuance of the, before imposition of the penalty. Stop. Situated thus the present writ petition. Mr. M. Sharma, learned so-and-so, submits that the inquiry officer despite the direction of this court to grant opportunity to cross-examine the prosecution witnesses, comma, did not give such fresh opportunities as per the mandate of this court. He further submits that pursuant to the list of witnesses appended with the memorandum of charges, 2 witnesses have been subsequently added. And in fact, on 27/1/2025, during the inquiry proceeding, another witness, to the utter surprise of the petitioner, was brought in as prosecution witnesses. Correct?
Badrul Islam.
Hmm?
Badrul Islam.
He accordingly submits that the element of bias is writ large in the departmental proceeding, and hence the entire inquiry proceeding is vitiated. In support of his aforesaid submissions, he further submits that the inquiry officer at the time of submitting the inquiry report has acted as an adjudicator. Right? You said
My lord.
as an adjudicator instead of the jurisdiction. Instead of inquiring into the matter and recommended the proposed punishment to the disciplinary authorities.
Dismissal from service.
Dismissal, recommended punishment ko isa to. He further submits that the Executive Council, being the disciplinary authority, by resolution dated 21/3/2025, had already accepted the recommendation of dismissal of the petitioner as stated in the inquiry report dated 13/2/2025 and presumed the guilt of the petitioner even before the petitioner had a chance to defend his case before the Executive Council. This indicates a premeditated mind, rendering the entire submission of reply by the petitioner an empty formality. In support of the aforesaid submission, he relies upon the following decisions. Page 5 of the compilation at Papa. I think I've covered all your.
The fact that the proceeding had commenced on 6/1/2025 and that was not indicated to the petitioner, which is at page 4, my lord, the last paragraph, my lord. Page 4, last paragraph.
Of this.
Yes, madam.
He further submits that he further submits that the petitioner, though had prayed before the IO by his representation dated 6/1/2025 for 14 days' time to find a defense assistant for his assistance in the departmental proceeding. However, the said prayer was rejected by the inquiry officer by reply dated 6/1/2025, where a period of 7 days was granted to the petitioner to find his defense assistance. However, he draws the attention of the court that although the petitioner does not however, he draws the attention of this court that though this court in WPC 351 of 2025 had already decided the same issue that was decided against the petitioner, the IO on the very same day, that is 6/1/2025, had failed to mention that the departmental proceeding had already commenced and the deposition of Sri Biranshi Kumar Das, PW1,
madam.
Former VC of Bhattadev University, PW1 was taken. He further buttressed that there was no whisper of this fact by the inquiry officer in his reply. Per contra, Mr. So-and-so Fukan, while vehemently opposing the prayer, opposing the relief sought in the writ petition, submits that the inquiry officer could record his recommendations in addition to fate of the charges, and the disciplinary authority is not bound by the said recommendations. He further submits that unlike criminal proceedings, departmental proceedings does not require high degree of probity, and some evidence, in contrast to no evidence, is enough to hold the delinquent guilty of the charges. He further submits that in the instant matter, opportunity of cross-examination of 3 witnesses were asked after 3 days of conclusion of the examination of witnesses concerned. Correct? He further submits that the court would not enter into the adequacy / inadequacy of the evidence in the departmental proceeding unless it is perverse or of no evidence. He further submits that the delinquent is entitled for putting forward his response to the inquiry report, after getting intimation about the provisional tentative acceptance, or for that matter, non-acceptance or partial acceptance of the inquiry report, and the delinquent should not make any response if the inquiry of report with proof charges is not accepted by the disciplinary authority concerned. In support of the aforesaid submission, he relies upon the decision of the apex court in Yoginath D. Bagde versus State of Maharashtra and others, reported in 1999, volume 7, SSC 739. He further submits that the departmental proceedings is a continuous quasi-judicial process and up to the stage of penalty imposed, if there is any, and there is alternative remedy available including appeal review provision even after the stage of penalty imposed. Hence, prior to such appellate / review stage, moving the constitutional court at any stage in the midst of the disciplinary proceeding would be a premature one, making way for opening a floodgate of litigations, unnecessarily stalling the entire disciplinary proceeding. He accordingly submits that the instant writ petition prior to the imposition of the penalty or acceptance of the recommendation of the inquiry officer is premature. This is what you want to say? Because you have come at that stage when that resolution was taken to accept. At that stage you have come.
Yes, madam.
He further submits that the delinquent has asked for extension of time for making his response to the inquiry report, and at the same time has moved a writ petition before this court using 2 fora at the same time, which is not acceptable in the eyes of law and is regarded a misconduct on his part. He further submits that under the Black's Law Dictionary 6th edition, the word accept within quotes is defined inter alia within quotes to receive with intent or retain, quote closed. And in the instant matter, the post accepted within quotes, accepted. Executive Council's Agenda number 8 dated 19/5/2025, in which meeting the disciplinary authority accepted the inquiry report in provisional tentative manner only and thereafter sent it for response of the delinquent. He further relies upon the aforesaid case laws. The goটেই লিষ্টখন দি দিবা খালি এই number 8 to দিব নালাগে Yoginath আগতে দিয়াই দিছো I think I've already covered this submission. Judicial review is to consider whether conclusion is based on evidence on record. I think that I have already included in your evidence, in your submission, right? Perverse.
Only on this Madhukar
Hmm?
judgment, my lord.
Which one?
1991 1 SEC,
Madhukar, I've seen court's interference, reappreciation of evidence.
para 7.
Man, you see, he has not argued on reappreciation of evidence. He's not gone into that aspect.
Only that para 7, my lord. That would be,
But that is on reappreciation.
my lord.
That he's not touched that point. He's not on perversity or anything. He's on natural justice. Isn't it, Mr. Sharma? Okay, right. I have given my due prudent, I have given prudent consideration to the arguments advanced by the learned counsels appearing for the parties and have perused the materials available on record. I have duly considered the case law cited at the bar. Such fat volume in his written arguments have come from both sides. Huh?
The case laws, the case laws are.
Anyway, let me make an attempt.
Yes, madam.
That's the biasness judgment, my lord. That was sent to larger bench, my lord.
I may not get into that aspect, Mr. Fukan.
You know, larger bench, fine.
First, where is the first memorandum is where?
My lord, 23/10/2024, that is at
Okay,
page
okay, got it.
34, my lord.
It appears that the petitioner was issued a memorandum of charges on 23/10/2024. Wherein under it appears it appears that the respondent university, pursuant to the decision to hold an inquiry against the petitioner within bracket academic registrar under suspension, and the Rule 7 and 9 of the Assam Services Discipline and Appeal Rules 1964, read with Rule 4 of the Guwahati University Employees Conduct Rules 1975, submitted memorandum of charges to the petitioner on 23/10/2024, along with statement of allegations in support of each article of charge, and a list of documents by which including a list of witnesses by whom the articles of charge are proposed to be sustained. Stop. Upon perusal of the list of witnesses, the following witnesses have been proposed to be produced as prosecution witnesses. Page 41 to 6. Subsequently, on 1/1/2025, after the inquiry proceeding has started, the inquiry officer subsequently. No, after the inquiry officer was appointed, issued a summon to the petitioner on 1/1/2025, requesting the petitioner to appear before the inquiry officer on 6/1/2025 in the venue and time mentioned therein. Pertinent that in the list of witnesses enclosed along with the said summon, the following 6 names are proposed to be produced as witnesses on that date. Quote unquote 1 to 6, page 59. It appears that Rafiqul is also new, na?
My lord, in fact, 3 and 4 that your lordship see,
Are new.
we don't know 3 and 4 can be, because if your lordship comes at page 40,
Officer in charge.
yes, so who is the officer in charge? Eventually we figured, my lord, and the officer
Is 3 a new or he's the officer in charge?
officer in charge is actually Singharam Mili. So Rafiqul R.H. Chaudhary is in addition to the list earlier, my lord.
That was not there.
No.
It appears that the names R.S. Chaudhary appearing at serial number 2 and Singharam Mili APS appearing at serial number 4 are newly were not earlier mentioned
Yes, ma'am.
in the list of witnesses supplied to the petitioner. However, it is stated at the bar that Singharam Mili is the officer in charge, ACB police station come SP. Then I think then ACB, na? Then ACB police station come SP Vigilance and Anti-Corruption Assam Guwahati, who was shown as one of the proposed witness at serial number 3 in the initial list of witnesses furnished to the writ petitioner. Stop. So Rafiqul appears to be not there. That's an admitted position. Admittedly, Rafiqul Hassan Chaudhry is not in the list of witnesses furnished earlier in point of time to the writ petitioner. Thereafter, on 6/1/2025, definitely, accordingly on 6/1/2025, the petitioner submitted a reply in response to the summon dated, aforesaid summon dated 1/1/2025, which reads as under, quote unquote, page 62. This was after or before? This was before the inquiry, before the proceeding on 6, na?
Yes, my
On that same day, before
Yes,
the
ma'am.
proceeding.
Yes, my lord. In fact, I had been summoned by way of the letter dated 1/1/2025 that your lordship had just.
For 6/1/25 proceeding.
Yes,
So that day you have given this letter.
yes, my lord. At page 62.
And then you appeared also.
I did not appear, my lord. I had sought time and time was granted by them at page 64.
এইটো চিঠিখন লিখিব কোট আনকোট নকৰিবা কি বুলি লিখিলা the petitioner sought 14 days time to enable him to avail why you sought time for defense assistance?
Yes,
Because
ma'am.
that was not given.
That was not given. In fact, what had happened, my lord, is that the letter dated 1/1/2025 was sent to an email which was not in use at that point in time.
Sought time for cross-examining and sought time for postponing the inquiry proceeding to another date, which the inquiry officer,
The presenting officer.
which the presenting officer on 6/1/2025 informed the petitioner that his request for an extension of the next date of hearing by a minimum 14 working day, though cannot be accepted, however, however, 10 days 10 days time has been granted effective from 6/1/2025 to the petitioner to prepare his evidence before the inquiry officer.
My lord.
Stop. Accordingly, the date of inquiry has been fixed on 16/1/2025 at 11 AM. On 16/1/2025, where is the proceeding of 16/1?
My lord, it starts at annexure R, my lord,
Page.
page 67.
Now, that day, what happened?
That day, my lord, on 16/11,
On 16-1,
16-1, what had happened, my lord, was that the writ petition being 351 of 20.
no, but where do we get 16-1's proceeding?
My lord, that is at the inquiry report, my lord.
That's
Just take-
exactly what I wanted now.
Yes, my lord. Page 85, my lord.
84 is 6/1/25, 85, 16.
80?
84 is 6/1/2025, down below.
And 85 is the next date, my lord, on 16/1/2025.
Second line.
On 16-1/2025, the prosecuting witnesses were duly examined and their statements were recorded in the inquiry proceeding.
Small submission, my lord. Virensi Kumar Das deposition was already taken on 6.
I'm coming.
Yes,
I remember.
Yes, I'm
I
apologies.
remember.
Yes,
One
yes,
second. I'm
yes.
just trying to connect the
Yes,
dots.
ma'am. Yes, ma'am. Yes, ma'am.
However, interestingly, what transpires from the inquiry proceedings, what transpired from the findings of the departmental inquiry, which is enclosed to the writ petition as annexure,
My lord, it's
annexure
U.
annexure U,
Yes, my lord.
that on that despite adjourning the proceedings on 1/6/1/2025, as per the request of the petitioner, the three prosecuting witnesses appeared for the recording of their statements and cross-examinations. However, but that day nothing happened.
Page
Mr. Sharma, nothing happened.
The deposition of Virensi Kumar Das was taken on 6/1, my lord.
No,
That
it was not.
my lord, that information is missing, my lord, in the inquiry report. The date has not
But
been.
how do we say that?
No,
From
because
where?
it has not been refuted by the university, my lord. This is a categorical submission, my lord.
Page 84
Anyway.
and page 87, Virensi Kumar
এটা
Das.
তুমি নকবা।
Page 84 of that.
Anyway,
6/1.
কি বুলি দেখিলা?
84 section, 87.
No, no, সেইখিনি
Virensi
নকবা।
Das.
নকবা, সেইখিনি ক'ব নালাগে। তাৰপিছত তাৰ আগত কি আছিলে? Okay. Apt at this stage to refer to the inquiry proceeding, relevant portion of the inquiry proceedings, which is enclosed to the writ petition as annexure disluna, so and so. Quote unquote, you quote from page 85 to 80, page 85, 86, 87, 89, koi dekhi sab. 90, 91, 92, 90, till 97. Till Didia. Reading of the aforesaid, it appears that on 16/1/2025, Jiaur Pasa's examination was prosecution witness 1, Jiaur Pasa, was examined and also cross-examined by the petitioner. It further appears that apart from PW1, PW2 Anjat Brahma
My lord.
PW3 Singhram Mili PW4 Birinchi Kumar Das PW5 Rafiqul Hassan Chaudhary were also examined. However, the petitioner declined to cross-examine the said witnesses. It further appears that subsequently, on 27/1/2025, the petitioner was again given the opportunity to cross-examine the prosecution witnesses, i.e. PW 5 so and so, PW 6, no, 6 was new this time, no?
My lord, Badrul Islam was new.
Then don't say 6. PW?
Badrul Islam is PW 6.
I have seen. And what about the Prashanta He's the so only 5 was given, isn't it?
Yes, madam.
On 27, only 5 was given.
Yes.
PW prosecution witnesses with witness number PW 5 I R.H. Chaudhary. However, this time you examined, na?
On 16th, I declined Miller.
No, on 27.
I could do it only to RH Chaudhary.
However, no. And the same was cross-examined by the petitioner. On 27/1, opportunity to cross-examine the prosecution witness, and this time he cross-examined PW 5 I R.S. Chaudhary. Stop. It further appears that on that date, another witness, Badrul Islam, was produced as a prosecution witness, number 6, though his name was not circulated in advance to the petitioner. The petitioner, upon being asked to cross-examine, declined the same. It further appears that after Prashanta Verma is the presenting officer, right? So he presented the case. That is, he didn't adduce as evidence.
No one.
Thereafter, the petitioner was examined. Therefore, the petitioner adduced his evidence, defense evidence, and after completion of the inquiry officer recommended and held that the charges of misconduct brought out against the petitioner is proved beyond any reasonable doubt, and further recommended dismissal and further recommended petitioner's dismissal from service in terms of clause 46(8) of the Guwahati University Employees Service Conditions, Conduct and Appeal Rules 1970. Now that 78, where is that letter? Yes. It appears that after 3 days, since 27/1/2025, it further appears that on 27/1/2025, in the writ petition filed by the petitioner seeking defense assistance in the disciplinary proceeding in question, this court, by judgment and order dated 27/1/2025, while rejecting the prayer made therein, was pleased to direct that in the event the petitioner was not given an opportunity to cross-examine the witnesses, page of that particular page.
My lord, page 77. Page 77, my lord. The last portion of the second last paragraph.
77. Has not been able to cross-examine the 3 witnesses. Where do I get their names?
My lord, those names are at page 17, my lord.
70?
17, my lord. 17.
17.
17.
3 names, huh?
Anjad Brahma.
3 names. Anjad Brahma, Singhram Mili, R.H. Chaudhary.
R.H. Chaudhary was already conducted by me, my lord. My submission is that Birinchi Kumar Das on 6/1. It is my. Yes.
Virenshi was not there on 6/1.
He was, my lord.
So now the 3 names are Birinshi.
Yes, Birinchi, Anjad Brahma, and Singhram Mili.
Okay, sorry.
Yes, ma'am.
Anjad Brahma, Singhram Mili, and Birinshi Kumar Das.
Yes, ma'am.
Comma, the IO should consider giving an opportunity to the petitioner to cross-examine the witnesses in the departmental proceeding. Since on 27/1/2025, on the day when this court had disposed of the said writ petition, the inquiry proceeding was also being simultaneously conducted by the inquiry officer, wherein though R.S. Chaudhary was produced for cross-examination, the other 3 witnesses, i.e. Professor Birinchi Kumar Das, Anjad Brahma, and Singhram Mili, who earlier was not cross-examined by the petitioner, was not produced. That apart, since on 27/1/2025, and another witness, another prosecution witness was produced, whose name was not earlier circulated or included in the 2 list of witnesses furnished to the petitioner. The writ petitioner on 30/1/2025 communicated to the inquiry officer, wherein by referring to the aforesaid judgment and order dated 27/1/2025, requested to give opportunity to the petitioner to cross-examine the prosecution witnesses in terms of the judgment and order dated 27/1/2025 passed by this court. Full stop. Letter dated 30/1/2025 reads as under, quote unquote, page 78. Apparent, when reading of the said letter, it is apparent that on that the writ petitioner could only cross-examine two prosecution witnesses. Here, see, chart kora ase, serial number 1 or 3, serial number 1 and 3 likhi deba. While could not do the cross-examinations for the other prosecution witnesses, as his prayer for consideration of defense assistant was sub judice before this court in the said writ petition, wherein this court, while disposing of the said writ petition, granted the opportunity, directed the respondents to grant opportunity to the petitioner to cross-examine the said witnesses. In the event he had not cross-examined them earlier. Admittedly, the three persons were not earlier cross-examined by the petitioner. Mr. Phukan, Vijay Phukan is correct in his contention that on such and such date, 16 when the respondent university examined the said three witnesses, the petitioner had declined to cross-examine them. However, this court cannot be unmindful of the fact that on that date, writ petition and the WPC number 351/2025 was pending before this court for consideration of the petitioner's prayer for grant of defense assistant in the inquiry proceeding. And subsequently, on 27/1/2025, this court specifically directed the respondents to grant opportunity to the petitioner to cross-examine the said witnesses. That being so, the inquiry officer, upon receiving the letter dated 30/1/2025 and having been brought to notice as regards the judgment and order dated 27/1/2025 passed by this court in WPC number 351/2025, ought to have looked into the matter and granted the opportunity of cross-examination to the petitioner, as admittedly on the earlier occasion, the said witnesses have not been cross-examined by the petitioner. Interestingly, there has been no response or consideration whatsoever to the said letter dated 30/1/2025 communicated by the petitioner. In fact, in the affidavit in opposition filed by the respondent university also, there is no whisper as why the judgment and order dated 27/1/2025 passed by this court in WPC number 351 of 2025 was not complied with. Correct? That part is not there.
But my lord, that page 89, my lord, he has been given the opportunity to cross-examine.
The argument of Mr. P.J. Fukan that on 27/1/2025, the petitioner cross-examined prosecution witness R.S. Chaudhary is of no consequence, as R.S. Chaudhary on 27/1/2025 was further cross-examined by the petitioner. Correct? He was examined on both occasions.
Yes, my lord.
Was further cross-examined by the petitioner.
Lord, on 16th, he declined.
No, no,
27th, inquiry officer allowed him.
no, wait, ek minute, Rabba. 16 first decline or 16 also done?
Initially, I had declined, my lord, because
Okay.
the petition was made.
They only indicate, sorry, একটু কাটি দিয়েছেন কি বিলি লিখিলা no, that on 27 once the child তার আগত কি লিখিছিল sorry no, that the petitioner was given the opportunity to cross-examine the prosecution witnesses. However, he only cross-examined PW5 R.H. Chaudhary. Is of no consequence in as much as on 27/1/2025, as per the records of the inquiry officer, there is no evidence to show that the earlier prosecution witnesses, were also present on that day. An opportunity of cross-examination was granted to the petitioner. That apart, it is clearly evident that on 27/1/2025, this court had categorically directed the respondents to grant opportunity to the petitioner to cross-examine the prosecution witnesses, if not earlier done.
Yes, ma'am.
Since admittedly, the aforesaid three witnesses were not earlier cross-examined by the petitioner for whatever reasons be, it was incumbent upon the inquiry officer to comply with the directions passed by this court in WPC number so and so. That apart, it appears that though এটুকু বলা যায় Now turning to the other contention of the petitioner, that the Executive Council, by the impugned resolution dated 21/3/2025, had already accepted the recommendation of dismissal of the petitioner. Where is that rule?
My lord, 9(7), my lord, the Assam Services and Disciplinary Appeal Rules,
9(7),
my lord. Rule 9, subclause 7.
9. I don't think there will be time for the other council. Not fair that you all are waiting. It's already 4 o'clock. I think 30 minutes of working is there. I should have indicated before, but I was not sure, because the problem is that if I don't dictate in the open code, it's very difficult. I forget the facts, and it's easy to dictate in the open code with the presence of the councils. So that is why I follow that. But I'm sorry, you all are waiting. So I think you can indicate if joint dates are coming, you will be accommodated. All right? Yes. Kila. No, Hetu Nokoba. Apt at this juncture to refer to, yes, which is that rule?
9(7), my lord.
9(7). 9(7), Assam Services Discipline
Yes, ma'am.
Appeal Rules.
Yes, my lord.
Appeal Rules.
Yes, my lord.
9(7).
9 subclause 7, my lord. 9 is regarding conduct of the inquiry, and 9(7) is what the inquiring authority shall do.
9(7), yes.
9(7) and thereafter 9(8). 9(7) is primarily moved.
Apt to refer to Rule 9(7), which prescribes the procedure, which prescribes the procedure for imposing penalties of the Assam Disciplinary Rules 1964 DDBA, wherein at Subrule 7, where Rule Subrule 7 and 8 reads as under DDBA or 9 DDBA. Reading of the aforesaid, it is apparent that the that the inquiry officer shall grant opportunity to to the delinquent to cross-examine all witnesses, and after the conclusion of the inquiry shall prepare a report of the inquiry, recording its finding on each of charges together with reasons therefore. It is further apparent that the record of inquiry shall include the charges framed against the government servant and the statement of allegations furnished to him under Subrule 2, his written statement of defense, if any, the oral evidence taken in the course of inquiry, documentary evidence, report setting out the findings on each charge and the reasons therefore. However, in the present case, it is evident from the inquiry report that the inquiry officer, while submitting its inquiry report, not only recorded its findings on each charge, that has been done on each charge.
Yes.
However, he also recommended the penalty to be imposed by the disciplinary authority, which under Subrule 9, it is the disciplinary authority's power, which the disciplinary authority under Rule 9 is empowered to consider the record of the inquiry and record its finding on his charge, and as per Rule 10, which লাইনৰ কথা নকবা, which the disciplinary authority under Rule 10 is empowered to impose such penalty as may be warranted in the facts and circumstances of the case. It is thus apparent that the inquiry appears to have been that apart, where is that acceptance? Apt at this stage,
Lord,
now turning to the impugned heterogemal
Page
question
80, my lord. Page 80, my lord.
page
80.
80.
This is the cover letter, my lord, forwarding the entire inquiry report to the petitioner.
Now turning to so and so, which reads as under, a resolution of which was communicate and now turning to the resolution adopted by the Executive Council of the Respondent University in its meeting held on 21/3/2025, whereunder the report of the said report of the inquiry officer, after being accepted by the council, the petitioner was put to notice by letter dated 13/5/2025 to submit his response within 7 days from issuance of the said letter. Letter dated 13/5/2025 reads as under, quote unquote. Mr. Majumdar, is there something?
24/20. Lordship has already explained that this is going to take some more time and the Lordship will not be able to take it.
No, there is no time.
Yes.
Unless you want to
No.
be there post working hours of the court.
No, not at all.
I'll be happy to accommodate you, provided the other side is also willing.
The other side is here, my lord. Both the sides have agreed for 13th.
All right.
Lordship.
All right.
Ah.
Kitya?
13th is a Thursday hearing date.
This Thursday.
Next week.
Next.
Hmm.
It is clear from the letter dated 13/5/2025 that the disciplinary authorities at the after receiving the inquiry report, before putting the petitioner on notice as to why the findings of the inquiry officer should not be accepted, had already accepted the same. And accordingly, the petitioner was asked to show cause within 7 days as why the proposed action should not be taken against the petitioner. Proposed action, has been submitted for response. Since this court has already come to a finding that the inquiry of that non-granting opportunity to cross-examine the prosecution witnesses. Give me the three names, the three names and the other newly added.
But I'll, Singharam, will- yes.
Give me the four names. So these
Okay.
four names
Yes, madam.
has vitiated the entire, has resulted in infraction of the natural justice, the principles of natural justice. The inquiry report submitted by so and so stands vitiated. I think I will send it back to the inquiry officer to give you that opportunity and proceed from there on. That is the correct course of action.
The cross-examination of.
Yes, those four witnesses, and thereafter from there off, proceed from there, whatever cross-examination and
Cross-examination of 3 witnesses. but-
four. The newly added, he is newly added, he cannot be, so if he has to give an advance notice for that,
Miller. 3 + 1, 4.
that was not given. No, that to me, here it would go back. Having held so, the matter is remanded back to the inquiry officer to first give the reason as to why so and so has been added as a prosecution witness. In the event the respondent is insisting upon, Mr. Sharma, please hear this out. I'm trying to mold the relief
Yes,
now
yes, madam.
because it is important. I don't want any other mistake to go ahead. Because two things has happened. One, these three people, definitely that cross-examination I'll give you.
Yes, madam.
But the fourth one,
My lord.
his name was not given to you in earlier.
No, my lord.
So that now if I just give you the cross-examination, will that do?
That will do because we understand.
That
you-
why he has come.
But he has come. We
So,
understand that he has come.
then it will be easier to. So then the matter is remanded back to the inquiry officer to grant opportunity to the petitioner to cross-examine the four witnesses, i.e. so and so Guteda Namna Kudiriva, and after the cross-examination is completed in accordance with law, the matter shall proceed therefrom afresh. Okay. I will see if I need some editing, but I think that is the main part that I have given. Okay, and then accordingly allowed Kuridiba petition. I would set aside Kuridiba, hey resolution con. Accordingly, the resolution so and so is hereby set aside.
Just one small submission, madam, in this entire scheme of things, madam. I had also stressed on the aspect of bias of the inquiry officer. Now I understand that the entire inquiry report also goes.
I am not changing the inquiry officer.
No, the inquiry report also goes now, my lord. In fact, if you're.
The inquiry report goes.
The inquiry report goes and there has to be a fresh cross-examination. I'm grateful, madam. I'm grateful.
A fresh means not from zero.
No,
but,
from the
I
cross-examination.
understand that. I
So it
understand.
will go to that point where you will get your opportunity
cross-examine the
at Kuridim after giving due notice of the inquiry proceeding in advance to the petitioner. I'll emphasize that. Because I don't want these are procedural aspect, Mr. Fukan.
And most importantly, my lord, that the earlier court's order.
And
if
I
you-
may add one more thing so that second time the same acceptance problem don't come. I will put one of the judgments saying that acceptance cannot be at that stage. But nonetheless, Mr. Sharma, when I was reading it again today, right now, I feel ki maybe that was not acceptance, because you see that acceptance, they say inquiry, but they did not indicate what to propose, what punishment. So it is still debatable. But nonetheless, Mr. Fukan, let's not get into that situation. You tell your authorities that this is how it should proceed, because these small words can unnecessarily
I think, Lord, that provisionally accepted would be better, Lord.
no,
Otherwise-
why should even provisional accepted be there? Why should that be there? Those line of cases that you cite is on a different point. Here, the entire this acceptance business is for the disciplinary authority and the sub rule 9 of rule 9. Now, before that, he has to get a notice.
Lord.
Only after the moment the inquiry officer submits a report, because the report is against him.
Lord.
If the inquiry report was in favor of him, disciplinary authority is accepting, question of notice doesn't come.
Yes.
Question of
So-
notice will come on two occasions. One, if the inquiry officer thinks there are materials and they will accept, then only a notice will go.
Lord, I'm still in.
But the
doubt
word
whether
acceptance should not be there.
It should be received, Lord, I think. Lord.
Let's not get into that. Anyway, all I stands. Only thing, Mr. Sharma, Mr. Fukan, you will not get this order today. Huh?
No, that-
It's not possible. He's going to type it out. I have to do a little bit of editing also.
Lordship has been gracious
So,
enough to.
and tomorrow is a holiday. So I'm just saying it. It was a pleasure to hear you both. It was quite an, quite,
Facts.
you know,
I learned many things of that. We are extremely grateful.
no problem. All right.
I'm grateful.